Thank you for joining us after the break. If you were listening in during the break, you realized that our microphones were on and we solved all of the world's problems within that short amount of time. If you're just now joining us and didn't get to hear our hot mic moment, then sorry, you don't get to hear the solutions to all the world's problems. So we'll have to listen in for them on our next panel, which is panel 2, which we will dive into a topic that's near and dear to my heart: registered investment companies. The panelists will discuss disclosure trends, board oversight observations, the impact from rules pertaining to derivatives risk management, valuation, and the names rule, along with tailored shareholder reports for mutual funds and ETFs. So, without further ado, we will get started, and I will introduce our moderator, Rachel Loco, who is a senior special counsel in the Division of Investment Management. Rachel, I will turn it over to you.
Good morning, everyone, and welcome to the second panel of the day. My name is Rachel Loco. I'm a Senior Special Counsel in the Division of Investment Management. I'm honored to moderate this experienced panel today on registered investment companies. Please welcome my co-panelists, Mike Spratt, who is an Assistant Director at the Division of Investment Management in the Disclosure Office, Lucy Lewis, who is a Supervisory Attorney Advisor in the Chicago office, Salvatore Massa, who is a Senior Advisor and Strategy Officer in the Division of Division of Enforcement in the Asset Management Unit in New York, Chris Chase, who is a Senior Counsel in the Division of Investment Management, Stephanie Hoy, who, along with having been a colleague of ours a long time ago, is now a lead counsel in public policy and vice president at Dimensional Fund Advisors. I will start by really saying nothing new, but acknowledging the driving forces transforming the registered investment company market currently. We're all aware of the effects of the search for yield in a tough investing environment, the fast development and profoundly transforming tech such as AI, and the challenges that funds face in its adoption in all of the technologies, as well as structural trends such as the continued explosions of ETF, and all these changes are changing and pushing the industry obviously in a certain direction. Yet, because of the importance of registered funds as a major tool in wealth building and in building retirement plans for most Americans, the SEC, as their regulator, remains very active to ensure that registered funds remain safe vehicles that they're intended to be under the 40 Act. And that registered funds do what they're disclosed they're doing. So in that vein, the following rules are sure to be top of mind for every compliance professional: the shareholder report rules, the derivatives rule, the soon-to-be implemented names rule, just to state a few. And as you're all aware, the Division of Examination has published its priorities for the year, which by no means are an exhaustive list of the topics explored during a registered fund examination, but those priorities do give roadmaps on topics of interest, and some of them are, assessing registered funds compliance program in general, fund governance practices, the accuracy and consistency of disclosures to investors, the accuracy of reporting to the SEC, the oversight of service providers, both affiliated service providers and third-party ones, and various portfolio management practices, and other issues associated with market volatility and how funds manage those. So with such a busy agenda, we could go so many directions, but I will start with Mike. My first question would be, what major trend in the disclosure office are you focusing on currently?
Just make sure I'm on mute. Thanks, Rachel. And I think it's hard to pick a single trend, so I thought about one, but I think if it's okay, I'll take a little bit more time and talk about two that we're seeing. And when I discuss these trends, I'll also talk about the areas that we focus when we review filings by these funds. And even before talking about the trends, I thought it would just be helpful for this audience to set the stage and let you know a little bit about the Disclosure Office and IM and how we go about reviewing filings. We have an office of about 70 staff that review thousands of filings each year by new funds and existing funds. And the filings we review range from the prospectuses to the registration statements, to proxy statements, shareholder statements, basically everything that's filed, or a lot of things that are filed by registered investment companies, ranging from the mutual funds and ETFs to business development to companies, closed-end funds, and UITs. And when reviewing these filings, we provide oral and written comments to funds, who then respond to those comments in EDGAR correspondence, and eventually that all gets made public so that the public is aware of the issues that we raise and how they were resolved. So with that kind of background in mind, DREO, which is the nickname for our office, has kind of a front row seat, I think, in product trends, and that we're often the area within the agency that's first seeing new products that are being developed. And I think two that stand out over the last year are derivative-focused ETFs and funds that are providing exposure to private credit. The derivative-focused ETFs come in a variety of flavors. I think there are three that we tend to see the most, which are covered call funds, which are funds that sell options in order to get some income, and in exchange for that are willing to limit some of the upside that they could get from the performance of the underlying investments. Leverage and inverse funds that provide concentrated exposure to a single stock, an index, or even an ETF. And then defined outcome funds, which are funds that typically use what are called flex options to provide a defined exposure with upside exposure to a cap and downside protection typically to an index. I think for these, as we review these products, the commonality among them is that they're complex. And so I think our number one disclosure focus for these funds is ensuring that they clearly and accurately describe their strategies and risks. With that kind of particular, more general framework in mind, I think with respect to each product, there are also specific areas that we focus. For example, for leverage and inverse funds, we focus on whether the funds adequately explain the returns are measured over a single day, and that if an investor holds these funds for periods longer than a day, the return is likely to differ from the return of the underlying, just based on compounding and volatility effects. For single stock funds, which are a type of leverage and inverse funds, we focus on risk disclosure related to leverage, volatility, and counterparties, ensuring that investors have access to information about the underlying issuer, which can be a challenge for funds investing in non-U.S. securities, as well as compliance with our derivatives rule, which I know Chris will talk about later, and in particular, the relative VAR test that's required under that rule. And for defined outcome funds, I think our specific areas of focus, or heavy areas of focus, are on whether the fund clearly explains the sought-after outcome, including the mechanics of how the different caps, floors, and buffers work, as well as making very clear to an investor that if you purchase this product at a time different than the beginning of the outcome period and sell at a time different than the end of the outcome period, you may get a different return profile than that defined outcome, because the way these products are designed is to provide you that outcome over a specified period. So if you're transacting at points within that period, it's important that investors know that the outcome may differ. The second trend that I mentioned is registered funds providing access to private credit, another topic that's been focused on, I think, a lot in the media lately. And while it I think is often positioned as being a new issue, it's not always. In the closed-end fund space, BDCs have been in the business of providing private credit since the 1980s, but we have seen an acceleration of that trend in more BDCs and closed-end funds that are entering this space. And I think, we're starting to see even now some open-end funds that are looking to provide exposure to that asset class, whether it's through investments in CLOs or even investments in privately negotiated loans. When reviewing these funds, I think one area of focus is definitely on how the advisor sources, does diligence on, and values the investments. Another, and particularly in the closed-end fund BDC space, is the impact that interest rate increases have had. On the one hand, funds can benefit from these increases because it can increase interest income. On the other hand, we are seeing some cases where there's been some stress in portfolios as a result of interest rate rises. And I think this has showed up in some cases an increase in PIK income, payment in kind income, where essentially the borrower to the loan, instead of making the periodic interest payment, instead does not make that payment and instead adds the amount of the payment to the principal of the loan, which can cause some risk to the fund long term if that issuer ends up having financial difficulties. And so when we see an increase in PIK income, we often ask about the underlying causes of that increase, how it relates to valuation and credit risk, and whether it impacts the fund's ability to manage cash flows. We're also seeing in this private credit space a rise in private BDCs that register their shares under the Exchange Act and then file a form called Form 10, and then do private offerings to accredited and qualified clients. And I think one thing we've noticed in this area is that a lot of the entrants in the Form 10 private BDC space historically had experience and have experience in private funds, but not necessarily registered funds, and so sometimes have not appreciated the nuances of some of the provisions that apply to registered funds, like restrictions on affiliated transactions and capital structure. And just to give one example, we've seen cases where these funds have tried to kind of take side letter provisions that existed in private fund areas and migrate them into the registered fund space. And in some cases, those side letter provisions can cause issues under Section 18, which imposes limits on your capital structure and restricts your ability to treat different investors differently. So that's something that we've seen as an issue and something for our sponsors to be aware of in that space. And then last, getting back to the funds providing exposure to private credit on the open-end fund side, we're seeing more funds focused on CLO investments. We're now just starting to see funds looking to source private credit investments and have those in ETF wrapper. I think for compliance professionals and those that are considering this, the issue that should really be top of mind is the fund's analysis to ensure that having those investments in the open-end fund wrapper works and is consistent with regulations that apply around liquidity and things like that. So before turning it to Rachel, I think one last plug that I think is important for compliance folks in the audience is a lot of the investments and products that I just talked about in trends are filed with us under a filing type that would go automatically effective in 75 days. And that can put pressure, I think, on both the fund and the staff, in that it may not leave enough time for us to resolve disclosure and other issues in that filing. And some of the reasons why it might take 75 days or more than 75 days is both the complexity of the issues, but also the coordination that has to happen internally. We have experts across the division agency that will often have to consult. A lot of these novel, complex filings get the attention of our division director's office, of other commissioners, of the chair's office, and so there's a lot of discussions internally that have to be had before we're able to kind of narrow down the legal issues that we're focused on. And so when you are considering launching a very new or novel product, I would recommend that you reach out to the staff in advance and preview that and let us know the filing is coming and what issues you've worked through. And I think in the end, that's going to allow us to more quickly analyze the issues, get the right people involved, brief the right people, and I think in the end, both funds and the staff would benefit from that earlier process. So that was what I had on trends, and I'll turn it back to Rachel.
Thank you, Mike, and thank you for reminding us of the fact that the door is always open for discussion when it comes to novel trends or strategies. We have a very creative industry, which makes it very interesting to work with. But we all want the processes to be efficient for everyone, the staff as well as the operators. So that invitation, quote unquote, is definitely helpful to all parties involved. I will stay with you, Mike, and speaking about one of the new rules I mentioned earlier is the shareholder report rule, which is now being implemented. And I was just curious to see if you had any observations on this implementation for our compliance audience today.
Sure. As I suspect many are aware, the Commission recently adopted a rule that required funds to open-end funds and ETFs, mutual funds, to send to investors more concise and visually appealing shareholder report documents, kind of building on the framework that is used for prospectuses with kind of a summary prospectus type document, but migrated to the shareholder report space. And we have started to see the funds filing the new shareholder reports. The compliance date recently passed, and I think we have a team at the SEC that's been monitoring and looking at that first batch of filings that have come in. And one thing that stuck out to us is that we've noticed some pretty straightforward errors in how some of the materials are being presented on things that are pretty straightforward form requirements, and not really places where there are judgment calls, things that just look clearly inconsistent with the form, relating to things like how expenses are calculated, what's chosen as a appropriate broad-based index for performance comparisons, how information is posted to the website, how different data in that report is tagged. And so it's still in the early stages of compliance. And so actually just this morning, we published a public document that discusses some of these issues that we've noticed, and kind of highlights them for compliance professionals and for the industry. And our hope is that publicizing these issues and getting them out there early is going to help fix them. And so for those of you who have a role in kind of producing these shareholder reports, I'd recommend that you go to the SEC's website, and on that website there's a tab that would take you to the Division of Investment Management's website, where you'll see this public document that we literally posted, I think, 10 minutes before this panel began. So those are some early observations on the shareholder reports.
Thank you. So one last observation I may ask of you is, with names rule soon to be in implementation phase, do you have any thoughts to suggest to our audience as they're phasing into implementation?
Yeah, sure. So, right, with the names rule, it's a little behind the shareholder report, so the compliance date hasn't yet come up, but in conversations that we've been having with folks in the industry, it's clear that the implementation process has begun and funds are working hard towards compliance. I'd have two suggestions for the audience. I think first, let the staff know about issues that you're having or experiencing during compliance. To the extent that we're seeing kind of common issues across funds and the industry, historically we've considered doing things like frequently asked questions or FAQs to provide some public guidance around those questions. And actually that's something we did recently around the tailored shareholder report rule that we just discussed. And with the FAQs, there's also a 2001 FAQ on the names rule that was passed when that rule was first adopted, and we're actively working to update those FAQs. So as you're working through it, as you have kind of common questions that are bubbling up, reach out to the staff, let us know so that we can consider those as part of a new FAQ. The second thing I'd recommend is that when you start making your filings, to consider something that's called template filing relief. And this process is spelled out in a public document that's on the SEC's website, where the shareholder report document that I referred to, it was just posted. So for more detail, I'd point you to that. But essentially, the template filing relief program allows a registrant to make automatically effective filings when there are substantially identical changes that are made across a fund complex. So just to give an example, if you're a registrant that has several funds with the word growth in their names, growth is now picked up by the new names rule, and you're going to use the same definition of growth across a fund complex or multiple funds, you could make a single reviewable filing called a template filing that the staff would review. And together with that, you can make a request for relief that would allow those other funds with growth in their name to go effective automatically without the customary 60-day staff review. So this template review process, I think, is an efficient way for us to be efficient with our staff review resources, but also for funds to be efficient in kind of getting these changes incorporated across their fund complex.
Thank you so much, Mike. And on that part, on the names rule, I would like to maybe veer to Stephanie a little bit and ask you, as a practitioner, do you foresee any particular challenges already around the names rule implementation? I know that the date is still a little further away, but we know that everyone is already working frantically. So.
Yeah, sure. Thanks, Rachel. Well, first, I think when the rule was adopted, we were really glad to see that the staff had addressed many of the concerns that we had with the proposal. You know, we had submitted a comment letter on the proposal, as did many other managers and industry groups. And one of our main concerns was that the proposed rule had a really prescriptive approach to temporary departures, which could have had negative consequences for investors. So we were really pleased to see that in the final rule, the staff took commenters' concerns into account and made some positive changes. And as someone who writes comment letters for a living, it was really great to see the comment process and how it works. In terms of complying with the final rule, you know, firms have had to go through their entire fund lineup, look at the names of every fund, look at every fund's 80% test if they have one, look at the strategy and the portfolio holdings, and then think through which of those elements might have to change. I probably personally underestimated the amount of work that goes into naming a fund and constructing an appropriate 80% test. There's really a lot of thought and discussion that goes into a fund's name. And for us, those discussions have involved many teams across the firm. And of course, it's not just the prospectus that's affected. There are all of the fund marketing materials that may have to be adjusted as well if there's a name change. So certainly a lot of work going on to come into compliance with the amended rule. But, you know, overall, we were pretty relieved to see where the final rule ended up, and ends up in a much better place than the proposal. And also great to hear Mike say that the staff is looking at FAQs and revising the 2001 FAQ. That will be helpful as well.
Thank you, Stephanie. We do read all the comments rules, and we are always happy to start a discussion with funds, with the industry, whether it's as Mike mentioned, for new strategies, so we can, you know, iron out various issues or concerns the staff may have, maybe ahead of even of a filing, or obviously the comment process, or just general questions. Just know that when there are compliance questions on new rules, or even existing rules, any questions, the staff is, frankly, at least in the Division of Investment Management, and I think that's the case throughout the building, always happy to answer a call and start a discussion on any part. But the common process being the formal way of communicating with the public before a rule is taken very seriously. So I'm glad you participated in that process and that you saw the fruits of participating in that process. So the disclosure office in IM is not the only one, the only office focusing on the disclosures funds send to prepare and send to the SEC. So I will turn to Lisa, and my question for you is, you know, obviously disclosures are something that the Division of Examinations focuses on quite a bit. And so would you mind sharing thoughts on your division's approach towards disclosure in your examinations at this time?
Thanks, Rachel. I just want to start by just saying something that I think everyone will hear multiple times throughout the day, but as a preliminary matter, I just want to note for the group today that the Division of Examinations utilizes a risk-based approach to examination selection and scoping, which means that the areas that I'm going to touch on today are general areas of examination. All of them might be present in any given exam, or the staff may choose to focus on one or two of them, depending on the nature of the exam. So I just wanted to note that at the top, this is not a prescriptive outline. It's just a discussion about areas that would be subject to general examination. So focusing in on fund disclosure, when we're looking at fund disclosure, we're examining generally for clear and accurate disclosure that is consistent with the fund's practices. And we would typically conduct our review in the following ways. So first, we would review regulatory filings, looking at the timeliness of the filing, compliance with form requirements, any incomplete or outdated information in the filing, or potentially misleading statements in the filing. Potentially misleading statements could be with regard to fund operations, conflicts of interest, as well as actual portfolio management activities, so portfolio management approaches and investment strategies, as those things are observed in the examination process itself. And then second, when it comes to disclosure, we may review fund sales literature, including fund websites. In those reviews, we're looking for any untrue statements or omissions of material fact, as well as looking for consistency with any related disclosure in the fund filing. So kind of tracing, you know, crossing those, connecting those dots between what's filed and what's produced in marketing materials. And then finally, we may also examine the effectiveness of any fund processes or procedures that are in place to ensure that disclosures are timely, consistent, and accurate.
So one tool that might be useful at this point maybe has been a risk alert published yesterday by your office. So would you have a couple of words on this risk alert and you know how to use it, how often those come up?
Yeah, so I definitely encourage the audience to check out the risk alert that was published yesterday. There's a lot of great information in there, including specifics on some of these more general topic areas that I'm talking about, these more general examination areas. So there's a little bit more detail in the risk alert that might be helpful to practitioners related to findings that we've had in exams, investment company exams relatively recently. So definitely check out that risk alert. It's very useful and there are a few more details.
One area that's been I would not say new because it's always been a topic in compliance, but has gotten a little more attention over the past couple of years has been board oversight of funds. We know with the new valuation rule, for instance, some questions around 15C. Generally speaking of board oversight of fund compliance, how does the staff typically assess the effectiveness of funds compliance program?
So I'm going to start actually with talking about board governance and how the exam staff looks at board governance as a general matter. So The staff focuses generally on the responsibilities of the board as prescribed under the Investment Company Act or as designated by the fund compliance policies and procedures. And examinations of this area would likely assess whether a board is getting the information necessary to exercise their oversight responsibilities, whether the board is requesting and reviewing the information necessary to understand the matters that are being proposed at a given board meeting, as well as making the associated approvals that are being requested of them at that meeting, and whether funds and or their advisors are accurately disclosing necessary information to the board. So what kind of information is coming from the funds and their service providers related to these requested proposals or approvals. And some examples of examination areas for board governance could include board oversight of the fund's compliance program, as well as its service providers, board approval of advisory contracts pursuant to Section 15C, or Section 15 and Section, which includes Section 15C, board approval of a Rule 12b1 plan and any related agreements, as well as board oversight responsibilities as they relate to things like Rule 2A5 fair valuation, Rule 18F4 for the derivatives risk management program, Rule 22E4 as it relates to the liquidity risk management program. And then one final area, the staff may also review board meeting minutes to assess whether they appropriately document the matters considered and discussed by the board at the meeting, as well as any actions taken by the board at the meeting. So that's sort of an overview of how we would, generally speaking, approach like a board governance review.
Thank you. I will move on now to Salvatore, but back also a little bit to the point Lisa was making earlier about exam reviewing whether the disclosures actually would give us a match what the fund is actually doing. Salvatore, could you give us examples of cases where enforcement has unfortunately had to intervene, where we had found some of those lacking?
Thanks, Rachel. I'm certainly happy to. And cases, enforcement cases, I think can be good examples of just applications of these rules and concepts that we have. And there were two recent ones involving funds that I'll call them thematic funds that were focused on different environmental, social, and governance issues. In Wisdom Tree Asset Management, the advisor in that fund had managed 3 ESG funds that disclosed that the funds would exclude certain securities of what they described as controversial activities. And they would do this in the investment process. So these exclusions in the prospectuses were very unambiguous. For example, the funds would exclude securities of companies involved in fossil fuels, quote, regardless of revenue measures, end of quote. The advisor made similar representations to the board on this point. To accomplish screening out these securities, though, Wisdom Tree relied on third-party data from 2 vendors. And however, that screening data that it received did not align with the disclosures in the prospectuses and in representations to the board. In other words, here, Wisdom Tree was not screening out all fossil fuels related securities as it stated it would for these funds. There were similar issues with its efforts to screen out tobacco related securities where there was a similar representation made. One aspect here of the failure was a lack of policies and procedures that govern Wisdom Tree's ESG investment process. It could have addressed what was being represented against what was actually being executed by the investment teams. A second case with similar issues was Inspire Investing, where the advisor managed ETFs and separately managed accounts that were going to follow biblical values. So another kind of variant of ESG, although here it's focused on social issues. And like Wisdom Tree, the advisor had disclosed, through the fund prospectuses, that the advisor was going to exclude securities and companies that were engaged in certain activities that it had identified as contrary to biblical values by using a science and data-driven methodology to do so. However, it turned out in its application, the practice was actually much more ad hoc and didn't adhere to that description. And ultimately, the advisor then in these portfolios for the ETFs invested in companies that were arguably to be excluded from the portfolios. So, and again, in another parallel to Wisdom Tree, Inspire Investing also lacked policies and procedures that covered its investment process, and in particular, what was described as the process for evaluating companies' activities within its investment process to determine whether those activities were one of the prohibited ones that would exclude them from the portfolio.
Thank you. Those are very useful examples. I think to remember maybe a third case, which would be a good example. Maybe. I mean, again, those are just, I think, useful for everyone to look at, just to give a sense of what has prompted the Division of Enforcement to pique their interest in those cases.
Yeah, yes, no, and Rachel, that's absolutely right, and I think those two cases certainly have some distinct lessons from them. But there is a third case I know that is an interesting one that I think has gotten a lot of attention recently, and involves Macquarie. It's a significant case in many respects because I think it touches on a number of concepts for registered investment companies, certainly tied to valuation practices, but also involving issues related to cross trades and communication with the board. Macquarie advised registered investment companies and non-registered investment company clients offering what they described as an absolute return mortgage-backed securities strategy. And that strategy invested in a number of fixed income products, but was focused, I think, largely on items like collateralized mortgage obligations, so CMOs. And although the strategy had used a valuation service, it had made a determination, the advisor had made a determination that it was going to use round lot valuation for client positions. This was an issue because the clients, both the registered investment companies and the non-registered investment company clients, typically had held odd lot positions, which, as the order, the resolution related to the case noted, typically traded at a discount relative to round lot positions of the same CMOs. And the valuation discrepancy, as you may imagine, right, causes then these funds and also these other separate non-RIC client accounts to be overvalued. And for the advisor, I think that cascaded into a number of other issues. So first, in terms of performance reporting and maybe the theme of sort of saying what you do and doing what you say, they had inaccurate annual reports, or the funds did, I should say, and overstated performance, right, because they used the higher valuation from the CMO positions. Another issue here was that the advisor had represented that these positions were going to be liquid, which would provide for redemptions for clients within 1 to 3 days. However, the positions, particularly the odd lot ones, were more difficult to sell in the market. And this led Macquarie to engage in what appears to be different approaches to address the issue. One was engaging in cross trades with clients and then staging those sales to attempt to sell round lot positions by aggregating them. These strategies also resulted in losses for clients, and the transactions led to a variety of issues, of course, around cross trading, Section 17A, and of course the exemption for cross trading, Rule 17A7. And basically, there the issue was that the advisor McQuarrie failed to comply with the exemptive relief that you can use under 17A7, and failed to, for example, report those cross trades to the board, as well as take, for example, other competitive bids to determine whether the cross trade was being appropriately priced.
So just to reformulate a little bit what we're talking about in this case, they're tied to earlier conversations. The disclosure ended up, some of the disclosure and reporting ended up being inaccurate, but at the core of it, valuation issues and trading issues ended up cascading into those disclosure issues. So at the core of it, it was important to make sure that the valuation and trading processes were more precise. Is that the correct way of saying that? So keeping an eye on that and making sure that the trading personnel stays close to that. Another aspect is making sure that the right information gets to the board, so that the board can actually follow through on this, and also really parsing through what valuation and trading issues could mean for returns. So these are all the aspects I think we have looked at in this case. So it's I sense several policies and procedures that should have helped and triggered in these. If we're going to try to take what is of use to compliance professionals, these are the policies and procedures to, I guess, focus on, draft properly, and look at in their implementation. Is that an accurate way of stating that, or am did I miss it?
No, Rachel, I think that's right on, right? I mean, the case certainly involved a number of different violations, right? So it touched on, as you pointed out, valuation issues. So you had a violation of our Rule 22C1, I think, right? And I think that's right. A lot of this boils down to policies and procedures and addressing these different aspects of the business that then got missed ultimately and caused this kind of cascade effect.
That's right. One other case we mentioned earlier when we were preparing was the Van Neck case, which is more of I think a pure disclosure case. But I did like, I would like to see if you could share some thoughts on it, as I think that it's also illustrative of do what you say. Example, and I think this has been a lot of our conversation today. So if you would.
Yes, no, and this is an unusual case in some ways because it touches on the 15C process. I think it really does. In thinking about this as an example for compliance professionals, it really boils down to questions about an advisor's representations to the board when a board is voting on a fund launch or during the contract review period that is part of what we all know as the 15C process. So in Van Eck Associates Corporation, the advisor planned to launch a fund that was going to use an index, a social sentiment index is what it was described as. As part of that business plan, the advisor was going to obtain exclusive license of the index from a third party. And in order to promote the index provider retained a social influencer. And of course, then in an effort to incentivize the influencer, a sliding scale licensing fee arrangement was negotiated. The fee was a tiered fee, and the economics of it were that as the assets of the fund rose, the index provider and presumably also the influencer would receive a larger percentage of VanEck's advisory fee, and that could rise to as much as 60% net of certain costs that were built in. Notably, during the board's evaluation of the proposal to launch the fund, which included voting on the terms of the advisory contract for the new fund, none of the information concerning the sliding scale licensing fee or the existence of the influencer was disclosed here. In particular, the failure to provide the licensing information hobbled the fund's board here in terms of its ability to address the potential for economies of scale for the fund and the advisor's profitability, which would be affected as this fund would scale up. Although the board later learned about the influencer by the time of the next advisory contract review period, they were still not apprised about the economics of the licensing agreement. And I think, consistent with the other cases I mentioned, this, has an aspect of, policies and procedures, failures. Here, VanEck had used a template document to populate information related to the fund launch, but the document really didn't contain fields to address economies of scale and profitability.
Again, making sure the right information gets to the right people. So thank you so much. I think these are useful to mention as, they really do give an insight on what the rules mean as well as much as risk alerts or the rules themselves can be. So thank you for that. I would like to go back to a topic we mentioned earlier, which is the derivative rule, and its implementation has been highlighting in past division examinations the priorities after a couple of years of implementation, and I would like to move on to you, Chris, at this point. Do you have any observation for our compliance audience today? Background and
Sure.
Observation.
Sure. Thanks, Rachel. Yeah, so as you mentioned, the derivatives rule, also known under the much more exciting title of Rule 18F4, it had a compliance date of August 19th, 2022. So we've accumulated a little over 2 years of real world experience with the rule. There's a lot in the rule, but so just in the interest of time and with the goal of hopefully keeping everybody awake, I'm just going to focus on a couple of areas of the rule where we have seen some questions arise. And before I get into those specific topics, one thing I did want to point out, and Stephanie kind of alluded to this earlier, if your funds use derivatives and you haven't already, or you haven't done so recently, there is a 2024 exams priorities. And within that, if you go to the second bullet point on page 12, it provides a great overview of things to consider when assessing your compliance with requirements of the derivatives rule. I want to be clear, there is a 2025 priorities. Yeah, that's not what I'm talking about here. It is the 2024. 2025 is also great. And if you look at the 2025, derivatives are not specifically, or derivatives rule is not specifically mentioned, but the exam staff does point out again that they will continue to monitor compliance with new and amended rules applicable to RICs. Then finally, at an overall level, as Stephanie and Rachel, you both mentioned earlier, There is a risk alert that was just, I believe, published yesterday. And it also talks about derivatives risk management. So just things that everyone should be aware of with this topic on the whole. So now just to highlight a couple of areas of the rule that I hope are beneficial to this group. I want to be clear, I don't mean to suggest that these are in any way more or less important than other aspects of the rule. It's a rule with a lot of layers. But these are just two areas where we, in working with our colleagues in DREO and throughout the commission, those of us in the Chief Counsel's office have seen questions arise, and I thought these may be of interest to our audience. So first, don't hold me to this as I'm a lawyer, but I believe, and I avoid math at all levels, but I believe if you go through the rule and you count it up, there are 20 references to the word board in the derivatives rule. So my point here is simple. Board oversight is a key element of the rule. Make sure your board and your derivatives risk manager are aware of the rule's board-related obligations. Just as a high level, as a reminder, these broadly include the obligation of the derivatives risk manager to inform a fund's board of material risks arising from the fund's derivatives transactions, the board's oversight role when a fund is not in compliance with its VAR test limits, the board's responsibility to approve the designation of a fund's derivatives risk manager, and the obligation of the derivatives risk manager to provide the board with regular reports. So again, a lot of focus on board responsibilities within the rule. And so with that, I'll turn to the second element of the rule that I'd like to discuss today. And Mike briefly mentioned this earlier. This topic applies to funds that use the relative VAR test to determine their compliance with the derivatives rules limits on leverage risk. So many funds using the relative VAR test will need to select what is a defined term under the rule, designated index, which they will then use as their designated reference portfolio, yet another defined term under the rule. And apologies, I know that's a lot of defined terms and a mouthful. So I think to put it simply, I'd like to talk about picking a designated index under the rule, if that's applicable to the way in which you apply the rule. So if it's applicable, your derivatives risk manager should be aware that they should closely review the requirements of the designated index definition. And one thing that we've seen questions arise, and in particular I would focus on, is that your derivatives risk manager should keep in mind that a designated index must reflect the markets or asset classes in which the fund invests. This can be a nuanced analysis. It depends on a fund's strategy, but conveniently, the adopting release has a very helpful discussion of this requirement under the very informative subheading of reflects the markets or asset classes in which the fund invests. So not hard to find. If your derivatives risk manager has not done so already, obviously looking at the entire adopting release is helpful, but also I definitely recommend looking at that specific discussion for purposes of this element of the rule. And the one thing I'll point to within that discussion, and apologies for reading it directly to you, but what we have found has been helpful to some funds is this portion of that discussion, which just says, a fund's derivatives risk manager may determine that, although an index is available that reflects the markets or asset classes in which the fund invests, the fund strategies do not involve the kind of risk that is associated with the market risk of the index. And the index, therefore, does not provide an appropriate reference portfolio for purposes of the relative VAR test. So again, just highlighting it's a nuanced analysis. And again, the board oversight of that. So again, to bring it back to my first point about board oversight, don't forget that the board has an oversight role here as well. The rule requires that the derivatives risk manager's annual report to the board include the basis for the approval of any designated reference portfolio. So key point again, board oversight. Make sure the board is aware of those responsibilities and that they are involved. So I hope that those two highlights are helpful in applying the derivatives rule. Again, I do want to point out, I'm not saying that that is all there is to the rule. We are very well aware there's a lot more to it, but hopefully those two elements, as I said, those are questions that we've seen come up. Hopefully giving a little more context is helpful to people into what to focus on that. And with that, hope I've kept you all awake. And Rachel, back to you.
I just had a quick follow-up. So obviously, board oversight of the derivatives management the, the process is important, but then what has changed on the day-to-day management of derivatives oversight that would translate for that would mean something what our compliance audience needs to look at.
I mean, I think for what has changed from day to day from 2022, from passage of the rule or from compliance
Yes.
to the rule.
Yes. What
I think
advice would you have for the day-to-day?
I mean, I think from a day-to-day perspective, from what we've seen, and Mike may even have more insight into this, but from what we have seen, people are understanding it better. People are understanding the implementation of it better. Products are changing. The rule came into existence before some products existed. So the rule obviously didn't necessarily contemplate those. There's single stock leveraged ETFs, which I think Mike referenced earlier. Those, if you read the rule, you look at those, it's not a perfect matchup, but there are ways to make it make sense. But I do think that from what we've seen, questions are getting less and less. Hopefully that means that the industry is understanding it more and more. And that, again, as has been discussed earlier, please, if you have a question, if you're not sure how the rule would apply to your product, come in, talk to us, talk to Treo. Don't put it in a filing and surprise us with it. It's a lot easier if we know ahead of time and we can work through it with you.
I mean, we will see it if it's in the filing, but having, as Mike mentioned, having a automatic, a deadline basically getting in the way of the conversation is not necessarily always helpful to all parties involved. So certainly, the rule was drafted with meant it to be as flexible as possible for new products in mind, but obviously new products weren't existing at the time when we wrote the rule, so the rule is flexible for that reason. But when it comes to implementation, conversation ahead of time is really helpful. But I mean, again, it can go. The conversation can go through disclosure. The chief counsel's office also takes calls from the industry if this is the route you prefer going. So again, the doors are open for conversations and to help with implementation, novel implementation, less than clear implementation. We are here. Thank you so much, Fred.
Absolutely.
And now I will move back to Stephanie. I hope you don't feel alone as the representative of the industry. Many of us from your time here, so hopefully we don't bite. But I have a very open question for you. What keeps you up at night as a practitioner?
Yeah, well, I think I can probably speak for most of the industry in saying that one of the perennial challenges is, how and really when to allocate resources when new rules are proposed and come into effect. So in 2021 and 2022, there was that flurry of rules being proposed. And at that time, I think there was a lot of anxiety in the industry. First, a lot of the proposed rules had really short compliance periods. And then second, there were so many rules being proposed that there was this fear that if they were all adopted at the same time, we'd have simultaneous compliance periods or overlapping compliance periods, and it would just be a lot of stress on compliance professionals in the firm in general. And I think there were a lot of people wondering, should we try to get ahead of any of these? Can we afford to wait to see what the final rule looks like? Or, what can we do in advance so that we're not scrambling when those compliance dates come into effect? And then over the last few years, as rules have been finalized, you think that some of those questions about timeline would go away, right? Because now we know what the final rule looks like, we know what the compliance deadlines are. But in the last few years, there's still been a lot of uncertainty because so many rules have been challenged in court. Now we have that added challenge of how much time and money do you want to spend to come into compliance with a rule that might end up getting overturned by a court. And of course, all those calculations really depend on a firm's business and how much they're directly affected by the rules. And then I guess I'll be the first or maybe only one here to mention the election. But of course, there's plenty of speculation out there as to how the SEC's priorities will shift under the next administration. But there's also the Congressional Review Act, which is something I didn't know very much about before this year. But that act gives Congress the ability to review and approve certain agency actions, like rules that have been finalized by the SEC. And I won't get into the nitty gritty of the Congressional Review Act, its look back mechanism, but basically if Republicans do have control of the House, it's possible that Congress could pass joint resolutions to disapprove some of the final rules that the SEC has adopted over the last 6 months or so. So that's just yet another level of uncertainty as firms are looking to come into compliance with some of these new final rules.
So I hear overall, it actually keeps you up at night is uncertainty on resources, uncertainty of, what is there actually to do. I can't comment further, but this is actually very helpful to hear. Thank you. So in that vein, I think one of the running points of this conversation has been that the staff wants to help. Are there any topics or any outreach incentive that the staff could perform that would be useful to fund compliance professionals in their opinion?
Yeah, I don't know that I have any specific topics, but I think the industry always finds it helpful to hear the staff's views. So conferences like this are great. It's really great to hear a little bit more color from exams and from enforcement on what they've been thinking and focusing on. When it comes to new rules, I think FAQs are often very helpful, particularly if they are published before the rule goes into effect. And then even after the rule is effective, staff observations are often super helpful. So that document that Mike mentioned, that's just posted today on Common Issues with Tailored Shareholder Reports, I took a quick glance at it, and it's great that there's so much concrete examples in that document. So the industry, I think, certainly appreciates this type of guidance.
Thank you. FAQs do not happen in the vacuum. They happen from the questions we receive from you guys. So again, another plug to encourage you guys to reach out to us. There are many ways. If you end up, seeing the name of someone on the staff, that you can reach out to us. Like I said, Chief Counsel Office in the Division of Investment Management or the Disclosure Office, whoever is your contact, where you file your disclosures. And these FAQs show that when you talk to us, as we can hear those questions over and over, we can really assess that there is a need for us to speak and to clarify certain points that that may seem clear to us as the rules are being implemented, but not necessarily to practitioners. And so the input, the output on those guidances can only be as good as the input we get, which is questions. So thank you so much for mentioning that. And yes, I will encourage all of you to definitely go in this direction. With that, I will say thank you to everyone for joining us this morning. We are giving you 5 minutes early for the lunch break at this time. I believe the third panel on private funds will start at 12:30. So please take some time for lunch, water, take a little bit your feet, your body, and we are looking forward to seeing you soon in 35 minutes. Thank you again, Salvatore. Thank you, Stephanie. Thank you, Lisa, Mike. Thank you, Chris. It was really a pleasure having you this morning.
Thanks, Rachel.
Bye, everyone.
Yes, thank you.
Welcome back, everyone. Our next panel for the afternoon will focus on private funds. This panel comprises This panel comprises of a variety of fund topics of interest, including filing accuracy and Form PF amendments, the marketing rule as it pertains to private funds, valuation for private credit investment, and real estate assets, as well as fee and expense issues and conflicts. Jennifer Duggins is the Assistant Director and co-head of the Private Funds Unit from the New York Regional Office and is our Panel 3 moderator. Jen, welcome, and the floor is yours.
Great, thank you, Marshall. Hello, everyone. We hope you had a nice quick lunch. Thank you for coming to our panel, which we know is a hot topic around private funds, current topics in the space. I want to introduce my panel. To my right is Lee Greenwood. Lee is an Assistant Regional Director in the Division of Enforcement in the Asset Management Unit. Adele Kittredge Murray is a Private Funds Attorney Fellow in the Division of Investment Management. And then we have Michael Noose. Mike is currently the Chief Administrative Officer at Brevin Howard U.S. Investment. Important to note, though, that Mike was a fellow staffer a couple of years ago when he was also a Senior Private Funds Attorney Fellow in the Division of Investment Management. Mike, we're so happy to have you on our panel. Thank you for joining us from industry, an important voice that we'd love to incorporate into our topics today.
Thank you.
Thank you. We'd like to get started talking about the marketing rule and specifically private fund related topics. There will be a marketing rule following this marketing panel following this panel. So our focus will be at the top talking about those matters that we believe are pertinent to private funds. And to do that, last but not least, is introducing Shane Cox, who is Regulatory Counsel in the Division of Examinations, working with the Private Funds Unit. Shane, thank you and welcome from Philadelphia.
Great, thank you, Jen. And let me also start by saying how grateful I am to all of you who made the time to attend the Private Funds panel. Hopefully I'll cover some topics that you find useful and can take back as you think about ways to improve your compliance program. Talking about implementation issues for private fund advisors under the marketing rule. On exams, where I encourage our staff to begin their analysis is whether or not a communication meets the marketing rule's definition of advertisement. As Jen mentioned, we have another panel after this that is marketing rule specific, and we'll go into more details about the definition of advertisement. But broadly speaking, for purposes of this panel, is it a communication made to more than one person offering the advisor services regarding securities to investors in a private fund advised by the advisor, or offering new advisory services to current investors? We had a question come in beforehand, and the question was, how would you define a one-on-one communication? Does it literally mean person to person or advisor to institution, which could involve more than one individual on both sides? It was a great question. And in the private funds context, I think this question is getting at the use of advertisements sent to consultants, placement agents, or possibly wealth platforms, where the communication may be designed to solicit multiple unrelated investors in the private fund. If the communication is truly a one-on-one communication, meaning that it is designed for a single investor to invest in the fund, then I wouldn't view that as an advertisement under the marketing rules definition, even if it included hypothetical performance under the exception for communications with private fund investors. If, however, the communication is provided through an intermediary, so through consultants, other advisors, or promoters such as placement agents, then I view this as an advertisement because it's an indirect communication provided by the advisor for dissemination by a third party. On exams, we tend to focus on how the advisor uses its presentations and to whom the communication is directed. Another note I'd make is that if the advisor uses the same presentation for multiple investors, so a canned presentation about the advisor and its fund offerings, and it makes only minimal changes, such as the investor name, then we view those as not meeting the one-on-one communication exception and would see them as an advertisement. The release explains that customizing a template presentation or mass mailing by filling in the name of an investor or other basic information about the investor would not result in the one-on-one communication. So that's typically the lens through which we view communications made by advisors to investors, and whether or not they qualify for the one-on-one exception. Next, I'd like to shift my focus a little bit to performance advertising, which seems to be where we see the most issues on private fund exams. Overall, I'd say where issues arise is when there's been a breakdown between one of three key areas within a private fund advisor. First, the investor relations function, which I'll include your traditional marketing and sales people, along with portfolio managers or founders who have an active role in pitching the private fund to prospective investors. So, is the advisor representing its strategy and past recommendations appropriately and putting performance information in the proper context? Two, the accounting back office function. So whoever at your firm is responsible for calculating returns, which at some places could be a third-party administrator, has the performance that is being shown, whether gross or net, been calculated accurately? And then third, the legal compliance function. Could be a CCO, general counsel, or someone within the compliance department tasked with reviewing advertisements to ensure compliance with the marketing rule. Have appropriate disclosures and legal disclaimers been included in the advertisement? And has the advisor adopted and implemented reasonably designed policies and procedures related to the performance shown? When these three functions aren't working together in unison, advisors tend to have deficiencies on exams under the marketing rule. A couple of specific performance advertising areas where we've seen deficiencies. First, I'll start with extracted performance. So the use of extracted performance, particularly case studies in the private equity fund context, or in the case of hedge funds, an advisor wanting to highlight some portion of its existing fund. So for example, showing the performance of a convertible ARB strategy within a broader relative value multi-strategy fund, or a long-short fund wanting to show the performance of a particular sector, such as healthcare stocks, or a global macro fund wanting to show returns on sovereign debt, often in the hopes of raising a new fund that's focused on that particular region, sector, or strategy. I understand why advisors want to show this information, and I see why it might be beneficial to investors to know how a particular portion of a portfolio has performed in the past, and in the private equity context to see how an advisor has successfully implemented a turnaround strategy at a portfolio company. And I want to see investors getting the information that they need to make informed investment decisions, particularly when you're asking them to write a check for a new fund that could be closed end in the case of private equity, or have some sort of a lockup period in the case of a hedge fund. To me, however, all of the scenarios that I've described where an advisor is pulling out the performance of a piece of a single existing private fund seem to meet the marketing rules definition of extracted performance. And to meet the requirements of extracted performance under D5, the advisor must provide or offer to provide promptly the performance results of the total portfolio from which the performance was extracted. Further, if the advisor shows gross performance of the extracted portion of the portfolio, then the advisor must also comply with the net performance requirements under D1. I'd highlight that our colleagues and IM issued an FAQ dated January 11th, 2023 on this specific issue. We received another question before this panel regarding the January 11th, 2023 marketing rule FAQ. Would the SEC panelists have a view about whether itemized gross returns of each individual investment in a single private equity fund, along with that fund's net return, is in compliance with the guidance provided in the FAQ? The thought is that the fund's net return is showing the actual net return of the group of investments in aggregate, which may be in compliance with a specific portion of the FAQ that states, accordingly, an advisor may not show gross performance of one investment or a group of investments without also showing the net performance of that single investment or group of investments, respectively. Again, it's another good question. In short, we would take the view that if you show the gross performance of an individual portfolio company, then you would also need to show the net performance of that individual portfolio company to comply with the requirements of D1. Under D1, net performance must be shown with at least equal prominence and in a format designed to facilitate comparison with gross performance. and it must be calculated over the same time period and using the same type of return and methodology as gross performance. Now, I recognize that this creates some complexity when calculating individual portfolio company net returns because fees and expenses are at the fund level. So there will be some decisions made about how to allocate those fees and expenses at the portfolio company level. When we review marketing materials that show individual portfolio companies, we tend to look for some sort of a reasonable methodology, recognizing that there will be some level of estimation. So including the net performance at the fund level when showing gross performance of individual portfolio companies would not be enough to meet the D1 requirements at the portfolio company level. And, unfortunately, I can't give prescriptive advice here, but perhaps Mike would care to share his views about what he's seen in the industry regarding extracted performance. And again, I do recognize that this creates some additional complexity for advisors, and I welcome the dialogue.
Thank you, Mike. Please go ahead.
So I think Shane's flagged appropriately how the rule is structured. When you take that structure of the rule and you try to apply it in practice, though, there's a tremendous amount of judgment that has to be affixed to it. First, I would say it's sometimes difficult to discern the difference between extracted performance and hypothetical performance. So, for example, Shane gave, if you're taking a strategy of a multi-strat out and wanted to extract it because you want to show potential investors of a standalone strategy as that extraction. But then if you decide you're going to have different leverage or add different parts to the strategy, then that extracted performance may actually be a hypothetical performance because you're imputing other assumptions. So from my perspective, I think what makes the most sense is that you give the net performance of the fund or whatever you have as a whole, and then on the extracted or hypothetical or a smaller piece of it, provide all assumptions you can. Should be similar if it's the same or similar investment strategy, expenses, fees, leverage, if the leverage may be different from that versus the parent fund that it's working through, finance charges, unencumbered cash interest payments, because when a subset is part of a larger multi-strat, it has the benefit of consolidating financing charges and interest charges. And then when you take it out, those assumptions may not be the same. Similarly, when you're talking on a private equity level, a lot of investors do want to have a case study, do want to have the individual fund. We'll have the individual fund, but they may want to have a case study on an individual portfolio company. I think the best way to do that is assume the worst in fees. So if the private equity fund is underwater at the time you're showing the case study, you may not have fees that attach to that private portfolio. But I would assume, as you're doing the case study, assume that if the fund as a whole were making money, then the 20% fee would be X. And apply some of the expenses that are on a full portfolio level to the individual positions. But the most important part is to just identify as much as you possibly can the assumptions that go into it. And if you have a choice, assume an assumption where the expense or the fee is going to be greater, so that you have less concern when you're having to defend it.
Thank you, Mike. Shane, please continue.
Yeah, and so just kind of following up on that, when dealing with extracted performance, I'd also remind advisors that extracted performance is still subject to all the general prohibitions, particularly A1, where an advisor can't make any untrue statement or omit material facts, A5, requiring specific investment advice to be presented in a fair and balanced manner, and A6, requiring advisors to present performance results or performance time periods in a fair and balanced manner. One way that the marketing rule adopting release suggests to meet the fair and balanced standard for case studies is to disclose the overall performance of the relevant investment strategy or private fund for at least the relevant period covered by the list of investments. So, for example, if an advisor to a PE fund uses a case study that shows a net IRR of 20% for a particular portfolio company from a fund, but then provides that the fund's overall net IRR was 8%, this may help put the performance in the proper context for purpose of the general prohibitions. and to help facilitate further discussion between the advisor and a prospective investor. Again, not talking about the specific performance advertising requirements under D1, just talking about the fair and balanced requirements under general prohibitions. Staying on the topic of gross and net calculations, I wanted to touch upon exam issues we've seen with advisors utilizing fund borrowings, such as subscription lines of credit. When advisors use certain fund borrowings, which you may want to think about broadly, there can be difference in the timing of cash flows when calculating IRR. So for instance, gross IRR may be calculated at the time the investment is made without reflecting the fund borrowing, while net IRR may be calculated at a later point in time when the advisor calls capital from investors to pay down the fund borrowing. IAM again issued an FAQ on this issue dated February 6, 2024, explaining in its view that presenting gross IRR that is calculated without the impact of fund level subscription facilities compared to net IRR that is calculated with the impact of fund level subscription facilities would violate the marketing rule, because the advisor would be presenting IRR calculations made across different time periods and using different methodologies under D1. I think we have seen advisors update their marketing materials for gross net to account for the impact of fund level borrowing. The area I'd point out where we see some advisors still struggle is with the second part of that same FAQ, which seems to suggest two options for dealing with the fund level borrowing to comply with the general prohibitions. One, a comparable performance option, and two, a disclosure option. So if an advisor chooses the comparable performance option, that is showing net IRR with and without the impact of fund level borrowing, on exams, we may ask to check those calculations for accuracy. If an advisor chooses the disclosure option, so describing the impact of fund level borrowings on net performance, we'll look to see that those disclosures are accurate. We may also inquire about how the advisor has used fund level borrowings in the past, what impact fund level borrowings have had on net performance historically, and if they intend to use them in a similar manner for the fund being offered. Sticking with performance advertising, I wanted to talk about hypothetical performance because we still see issues coming up with advisors to private funds using hypothetical performance. And I'll put the issues that we tend to see broadly into two buckets. So first, we see advisors failing to identify when performance is hypothetical performance. And hypothetical performance means performance results that were not actually achieved by any portfolio of the advisor, including but not limited to performance derived from model portfolios, performance that's back-tested, and targeted or specific performance returns regarding any portfolios or advisory services concerning securities offered in an advertisement. Here, what we'll see is, and I think Mike alluded to this earlier, is we'll sometimes see advisors pulling investments from multiple unrelated portfolios. So, for example, pulling all technology-related investments from multiple unrelated funds with the hopes of raising a single technology-focused fund in the future. Where the investments are pulled from multiple unrelated portfolios, we would view this as hypothetical performance, since the performance results were not actually achieved by any single portfolio of the advisor. Or another thing we'll see dealing with hypothetical performance is disclosures in pitch books that state something like 20% targeted IRR when talking about a type of portfolio company investment that the fund being offered intends to target. We would also view these targeted IRR figures as hypothetical performance. And when showing hypothetical performance, if these figures are showing it gross, keep in mind that you would also need to include a net performance figure to meet the requirements of D1. The kind of second bucket of hypothetical performance issues that we see, I think it simply involves advisors' failures to comply with all three prongs of the hypothetical performance requirement. Particularly prong one, by not adopting and implementing policies and procedures reasonably designed to ensure that hypothetical performance is relevant to the likely financial situation and investment objective of the prospective fund investors. Or prong two, by not providing sufficient information to enable investors to understand the criteria used and assumptions made in calculating hypothetical performance. On exams, we tend to scrutinize the disclosures made regarding criteria used and assumptions made. The last thing I'll cover on the marketing rule relates to substantiation, particularly the ability to substantiate performance figures. The marketing rule adopting release explains that performance returns would be viewed as statements of material fact. And with regards to substantiation, there's a specific books and records rule, Rule 2042A16, relating to performance. So that is, an advisor has to retain records or documents necessary to form the basis for or demonstrate the calculation of the performance or rate of return of any or all managed accounts, portfolios, or securities recommendations that are presented in any advertisement. So on exams, we may ask for backup of certain performance figures, and keep in mind under the general prohibition that the marketing rule prohibits an advisor from including a material statement of fact in an advertisement that the advisor does not have a reasonable basis for believing it will be able to substantiate. And so finally, maybe I'll give the last word to industry on this issue, but I would be curious to hear from Mike if he has any thoughts from an industry perspective about what challenges he's seen in implementing the substantiation requirements or any of the other provisions of the marketing rule. And again, I certainly welcome the continued dialogue that we've had on exams with industry on some of these complex issues.
Yeah, of course you do, Mike. Go right ahead.
Mike's up again. So private funds are really geared toward primarily institutional investors rather than retail. The institutional investors tend to be more sophisticated, and they actually want to see what a portfolio manager or a team has done in the past. And so I think there's sometimes rules are written with the expectation that managers are trying to avoid something or trying to do something that they would not otherwise be expected to do. But I think in the private funds context, it's often that you're trying to be responsive to the rules, but also to provide the information that the institutional investors are asking for because they are much more sophisticated. I think that the one area that is hardest in this with whether it's extracted or hypothetical, the industry generally refers to that as simulated track records. And the independent valuation is hardest where you're bringing up a PM from an outside place. So one of the things you could do if you're a star PM, you can come into a firm and ask for confirmation that when you leave, you will be given substantiation to be able to take your track record with you, what's known as portability of track record. If you're taking a PM, say, from an investment company, a mutual fund, usually that there's enough public information to substantiate it. But when you're taking a PM that's in, say, a multi-strat or a multi-PM and then bring him in and setting up a fund on her own, it's very, very difficult to provide the level of independent valuation to actually meet that requirement. And so sometimes you have to go qualitative rather than quantitative.
Thank you, Mike, and thank you, Shane, for that in-depth study on marketing and related to private funds. So now we're going to pivot and we're going to start with Adele, and we're going to talk about Form PF and some filing accuracies from the IM perspective, and we'll get some color from Mike as well in industry.
Thank you, Jen.
Of course.
So the Commission finalized 2 amendments to Form PF to enhance visibility into private funds and the risks they present and to improve data quality. The first amendment went into effect in December of 2023. It introduced current reporting by large hedge fund advisors and all private equity funds. These current reports provide the Commission with real-time information that helps us identify market stress and potential investor harm. These current reports must be filed as soon as practicable, but no later than 72 hours from occurrence. For a large hedge fund advisor, the trigger events include, first, extraordinary investment losses or losses over 20% of a fund's value. That's over a rolling 10 business day period. Second, a significant increase in margin of over 20% of the fund's value, an inability to meet a margin call or a margin default. Third, a prime broker termination or a material restriction in the relationship. Fourth, a default by a counterparty to meet a margin call or a failure to make a contractual payment after a cure period. Fifth, a significant disruption or degradation of a fund's critical operations. And critical operations are operations necessary for the investment, trading, valuation, reporting and risk management of the fund, or operation of the fund in accordance with federal securities laws and regulations. We're going to come back to this in a moment. There are two reporting events related to withdrawals and redemptions. The first one requires reports of withdrawal requests exceeding 50% of the fund's most recent NAV. And the other event trigger relates to redemptions and the inability to satisfy redemptions, or if the fund has to suspend redemptions for more than 5 consecutive business days. And for the private equity reports, there are 2 required to be filed on a quarterly basis. The first of the 2 is reporting on execution of advisor-led secondary transactions, which is a transaction initiated by an advisor or its related persons that offer private fund investors a choice to sell interest in a fund or convert their interest in a fund to another advisor vehicle. This is a fast growing area. And then the second private equity event report is when there is an investor election to remove a fund's GP or terminate a fund's investment period. And so these current reports have resulted in an advisor, developing monitoring tools to comply with the new current reporting regimes and the 72-hour filing requirement. Turning to Mike, from the industry perspective, do you know, or do you have any thoughts on how the industry is monitoring and or any challenges related to that or the filing requirement?
And have you had to make such a filing in your current role?
So both answer to both questions. I think a lot of the systems have had to be changed because some of the 72-hour current reporting is not based on a month-end period of time. And so where you have certain reports that are looking temporally, the cadence may not be sufficient for the current reporting. And people should have already reconfigured systems to be able to provide that level of information. To answer Jen's specific question, we did do a current report filing on a disruption of operations last July. If you recall back July, the CrowdStrike issue happened globally. I actually happened to be in our London office very early on a Friday morning when we noticed that a lot of the virtual desktop infrastructure was out. The portfolio management system, internal databases were all affected. Now, in our case, we had all the traders always had the ability to trade by mobile or by voice, but it's not entirely clear whether or not that would trigger. But we also did trigger our disaster recovery business continuity plan because of everything that was going on, particularly with counterparties, less so than internally. Internally, we were able to always trade, but we didn't get some of those systems up and running again until later that weekend. The 72 hours is interesting because it's 72 hours. It's not 3 business days or even 3 calendar days. So in our case, it was a 5 a.m. London time when it triggered, which would have been the middle of the night on a Sunday. And so our CCO actually had to go into the system on Sunday night in New York and filed before we had all the information, before we even knew where things were coming through, because counterparties weren't up for another trading day. And the way the form is set out, it's done not on an advisor basis, but it's done on a fund by fund basis. So if you have 24 funds or 50 funds, or some managers have multiple funds, the system is a little clunky, and you actually have to go in, cut and paste, and keep answering all the questions that it took hours to do. So I think that one thing to note from that exercise is just to make sure that you have incident reporting sufficient and that your technology, back office, accounting people all are aware of what the triggers are, and that you got a team ready to make the filings, because 72 hours is not
Quick.
long enough
Yeah.
if you've got it like this case on a Friday morning.
Thank you so much for sharing that perspective.
Yeah.
Yeah.
And so then the second amendment to Form PF was adopted in February of 2024, and the compliance date is March 12th of 2025, fast approaching. I would note that the staff received questions related to the compliance dates, and we recently posted FAQs related to the compliance dates on the SEC website. So we encourage you to visit those FAQs. And we also continue to consider questions and issues related to this Second Amendment and welcome emails and calls from the industry to discuss any questions that they may have. The Second Amendment provides the Commission with better insight into the operations and strategies of private funds and their advisors. And the changes include, 5 broad areas. The first being enhanced reporting by large hedge fund advisors on qualifying hedge funds, including how large hedge fund advisors report investment exposures, borrowing and counterparty exposure, market factor effects, currency exposure, turnover, country and industry exposure, central clearing, counterparty reporting, risk metrics, investment performance by strategy, and there are many new strategies included, portfolio liquidity, and financing and investor liquidity. The second is enhanced reporting on basic information in Section 1 about the advisors and the private funds they advise. And then the third is enhanced reporting concerning hedge funds, including more granular information on the strategies, the counterparty exposures, and trading and clearing mechanisms. It also amends how advisors report complex structures, given developments in how private funds are structured, and it removes aggregation for large hedge fund advisors. And so we would also just encourage the industry to look at all of the new definitions in the glossary and consider those in your, the filings, the upcoming filings after March 12th, and also to review all of the new instructions. So.
Thanks so much, Adele. We often get asked what are our areas of focus, and one of the perennial areas remains around valuation. For this panel, though, we wanted to talk specifically about private credit. Obviously, there is a valuation application to that, but we also wanted to speak more broadly about the focus on private credit with a perspective starting off again with you, Adele, from IM, and then we'll move to Shane in exams as well, and then over to Lee from enforcement for some color, a way to show that we do work collaboratively across divisions. So Adele, please again, if you don't mind.
Sure. So basically, the private credit is not a new strategy for private funds, but this asset class has grown significantly in recent years. And we are looking at these new developments and any potential market risks and investor harm this asset class may present as a result of its growth and evolution, including how these private funds are structured, how fees are structured, how fund liquidity is structured to match the liquidity of the underlying assets, and the interconnectedness to other market participants. The definition of private credit has also been evolving. The narrowest definition from more of a historical perspective is direct lending to middle market corporate borrowers, but it has become broadly defined and, at times to include even private asset-backed finance strategies and products. So we continue to sort of look at how private credit is being defined. Mm-hmm. And the growth in this asset class has also captured the attention of various market participants and regulators who are asking questions about transparency, valuation, conflicts of interest, and the interconnectedness to other financial institutions. And related to transparency, given that private credit is held in numerous types of fund vehicles, there is some data transparency. For example, registered BDCs report on 10Qs and Ks, and RICs report on NPORT, and the new Form PF, as we discussed just previously, provides additional detail on private credit strategies for Section 2 and Section 4 reporting funds.
Great.
From exams perspective?
Yeah, Shane, why don't you take that point?
Sure. I mean, I think, it's fair to say with the growth of private credit, you can expect to see us do more exams in this area. Our unit, our focus continues to evolve each year as we respond to new risks or changes within the private funds industry. I will say certainly there's been more press coverage of private credit lately, but we've been doing exams in this space for years, so it's not new, and I expect it to continue for us. If I had to hit on just real quick a couple areas where we may focus on examinations to advisors to private credit funds, certainly valuation, like Jen mentioned, so reviewing the written policies and procedures on valuation to see that they're reasonably designed and implemented. In particular, I think we'll look at how changes in credit quality at the borrower impact these valuations. So monitoring for payment defaults, covenant breaches, or whether a borrower is experiencing some significant financial distress and undergoes some sort of a workout situation, a reorganization, or liquidation. Further, we'll look at how changes in the market, so changes in credit spreads or yield, impact the value of private credit investments. What I would say, though, there's also related to valuation is we tend to focus on it from kind of a conflicts of interest perspective. So how does the deterioration of the value of a private credit investment translate into the fee calculation? So what do the fund documents say about when there's been an impairment, a write-down or write-off in private credit investment? What do the fund documents say regarding the invested capital base when an interest is accruing but not being paid? Is the advisor including the accrued but unpaid interest into the invested capital base for purposes of calculating the management fee? Separately, as we've seen, staying on conflicts of interest, as we've seen a growth in private credit funds, we're also aware that advisors may be operating funds side by side with other funds invested in different parts of a company's capital structure. So on exams, we're likely to review these conflicts, particularly if the company is experiencing some financial distress and it may be in one fund's interest for a company to go through restructuring, while that scenario may not be in another fund, another client's interest. So I'd encourage advisors to think about these issues. I won't go into detail again about marketing, but I would just remind you that the value of private credit investments can impact performance returns that are shown in the marketing materials. So we're sensitive to these issues, particularly when fundraising for a new fund. And overall, I would just say that this is an area where, if CCOs aren't ingrained effectively across the business, they can miss material issues where an advisor has a significant conflict of interest related to fees and portfolio management decisions, or issues related to performance marketing.
Thank you, Shane, for that great recap. And moving over to Lee, from the enforcement perspective, what are you seeing in your space?
Yeah, it's a good question. I mean, I think for us, certainly recently, an area of focus has been material non-public information, or MNPI, and how advisors in the private credit space come into possession of it, and what do they do with that information. So for us, the key provision that we think about is Advisors Act Section 204 Cap A. That provision provides for and requires registered investment advisors to establish, maintain, and enforce written policies and procedures reasonably designed, taking into consideration the nature of their business to prevent the misuse of MNPI. So, I mean, what that means typically from our perspective is that a generic off-the-shelf policy isn't going to work. You need to think about what are your business lines, how do they overlap, and what are you getting into next? Because we certainly see advisors moving into new business areas and saying to themselves, maybe they're moving a little more quickly to take advantage of a product, but are the policies and procedures that are required under 204A keeping pace? So for us, I think we brought a couple of interesting 204A cases recently in the private fund space. In particular, want to highlight two from the past couple of months. The first is the Sound Point case that I supervised, and the Marathon case. Those are from August and September of this year. Both cases involve participation in ad hoc committees of creditors, and the risks that can come along with that participation, the MNPI that comes into the advisor, and how that may impact other business lines. So let's first look at Sound Point Capital. Again, that's from August of 2024. Sound Point had a significant credit business, still does. It has a significant CLO trading business. In many cases, Sound Point came into MNPI by virtue of its credit business that related to loans in the CLOs it traded. Right. So the question is sort of what does 204A require in the context of that kind of overlap? Sound Point was aware, according to the commission's order, that it could receive that MNPI from its credit business, but according to the order, sort of the core policy deficiency here was that Sound Point didn't have written policies and procedures to assess the potential for misuse of MNPI in the context of the CLO trading. The order, I think, goes through a specific example of what can go wrong in the space, potentially. I think the example that's spelled out in the order is a situation where Sound Point comes into possession of MNPI by virtue of that ad hoc lender group participation. It sells a CLO. The next day, news comes out, price goes down, and because it was a first loss equity tranche sale, it had a material impact on the price. Bottom line, Sound Point sort of did not consider what the potential impact of that MNPI was on the CLO trade. Marathon case, fairly similar, from September of 2024. Again, regularly participated in these ad hoc creditors committees and interacted with investors, financial advisors, and consultants around the process of forming those committees, and came into possession of MNPI, didn't have adequate policies and procedures to address those risks. So I think the takeaways, and I'll give them from enforcement's perspective, and maybe Mike, you'll translate them into industry. But a couple, I think first and sort of, I guess, fairly obvious is advisors have to make sure that their policies take into account the unique components of their business lines. It's about assessing ways in which MNPI comes into a firm and how can the firm mitigate that MNPI risk through policies. Some firms that may mean information barriers. For some firms, that may not be feasible. I think a second and related point is that in a situation where an employee has MNPI and is also actively trading in other companies in that same sector, 204A may not be the only issue. I think as you see from the Panawat case, in which the jury returned a verdict in favor of the SEC in April, that can be insider trading in the context of the traditional elements of misappropriation theory, insider trading. Did you have a duty to the source of the information? Did you breach it? Did you trade on it? It's always something to be thoughtful of as well in this space when thinking about 204A. Third, I think having the policies and procedures from enforcement's perspective is, under the rules, not enough. You gotta execute them, you have to implement them, and I think the OEP Capital case from December of last year exemplifies that. OEP personnel didn't comply with the policies and procedures of the firm related to disclosing merger-related MNPI to current investors, potential investors, and other contacts that was required by OEP's policies. OEP used NDAs to try to mitigate the MNPI issues, but the bottom line was that using an NDA is not the same as maintaining and enforcing your policies. And in that case, OEP did not have policies related to how to use or consider NDAs. Fourth, arm your compliance group with the tools to be able to assess MNPI and its materiality. That certainly comes out of, I think, some of the lessons in the Sound Point case, establishing clear escalation protocols, and really giving compliance the tools to be able to assess the risks is a real takeaway. Finally, and I'll say this for all enforcement cases, prompt remediation and cooperation is incredibly important. We think about it at the beginning, the middle, and the end of our investigations. It's something that we think about when we craft settlements, and that cooperation, remediation certainly is reflected in our orders, including the Sound Point and Marathon orders.
Yeah, I mean, and I know, Mike, when we ask CCOs, what keeps you up at night, give us kind of top 3 areas. MNPI is literally either number 1, or number 2, or that's usually, or the only answer they come up with is, MNPI. And I know you have views on robust policies and procedures being absolutely essential for 204A compliance. So take it away.
Okay, so tie all of that up in a single box with a big bow. I think one of the things that people have an issue with is silos. So what happens is you've got credit guys that are just looking at private credit. You get somebody, fixed income is looking at bonds, somebody else is looking at equity. They may sit on the same floor, and whether or not they talk to each other, and you have policies related to each one. I don't think that's sufficient. I think it has to go across the board, because some of what you see from both Soundpoint and Marathon and some of the other cases, and what people tend to forget is that the breach of duty does not have to relate to the issuer of the security that's being traded, right? So you can have somebody sitting on an ad hoc creditors committee and realize that that company is the largest vendor to another company. And the fact that at the ad hoc creditor committee that they're going to enter into restructuring, that may affect the other company that's a buyer, right, or a seller. So I think that one thing that's incredibly important is to have a firm-wide conflicts committee. It can be called a conflicts committee, it can call it a compliance committee, it can be called a subcommittee of something else. But that something at a higher level with representatives of compliance, legal, front office, investment, marketing, to sort of tie in all of those issues and look at it from a high picture level. And then when you do that, you're much more able to create and craft the policies and procedures that hit across the firm, particularly when you're introducing new strategies and new events. When a few years ago, when I was setting up a startup hedge fund, I had a consulting firm come in, and I said, okay, now I need to set my compliance policies and procedures, manuals, blah, blah, blah. And they gave me the first draft of it. And I was like, okay, I want to change this, because it's not necessarily applicable to how we want to do it. This is where I want to put it in. And they wouldn't do it. They told me, this is our standard. This is the way we do things. And so I literally had to take it and rewrite half of it myself, because this consulting firm would not change it, because they had their marketing view of what their document looked like. And it just was not relevant for the type of trading that we were going to be doing. So it's extraordinarily important that compliance and legal, working together and working with the business, understand where the issues are and where they're going to come through.
Right.
I'll pick up one other point that Shane had raised initially when introducing the topic, and that is on valuation in private credit. That's also incredibly important. Back in the old days, when I first started working with private credit 20 years ago, what typically happened is that a credit, say a borrower, oftentimes a private equity portfolio company, would want to borrow funds. A bank would then set up a syndicate and go to other banks and go to other plain vanilla mutual funds, and then go to hedge funds. And then it got narrower and narrower. And post 2008 crisis, with banks reducing their balance sheet, what's happened is two things. One is that the holders of the private credit tend to be much more narrow, so you don't have third-party trades. Somebody selling a piece of a loan, for example, number one. Number two, there tend to be related party transactions. So you have a private equity fund that has the portfolio companies that need financing. Then there's a private equity fund under the same house, right? And then oftentimes it's a related party, not related in the sense of ownership, but of a similar management company.
Right.
And then what happens then sometimes is, rather than say you put out a 2 or 3 year term loan, instead of the term loan coming due and then you go back to the market, the private credit fund amends and extends for the benefit of the operating company. So then you get to a situation where you don't have a third party valuation. You don't have an independent party that's valuing it. And then all the risk then goes on the parent RIA and the management company,
Right.
because the OpCo and the private credit team have different incentives. And so on a valuation committee, that's also where I think you want to have compliance and or legal representation, finance. You want the business guys to put a presentation to go through it. But I think the vote and the determination should be through the control functions, accounting, compliance, legal, elsewhere. That's sort of a mishmash, but if there's any specific on, you guys raised a lot and I'm not sure I hit everything that you wanted to
I mean,
address.
we could talk hours about this, right?
And have.
Yes, absolutely. And I think this dovetails nicely into another perennial and our bread and butter topic of just conflicts of interest in general, but specifically fees and expenses, which is also something that we focus on, you know, in the day-to-day. And to that, we're trying to address, you know, audience questions as they fit into our conversation. And Adele first, and then Mike, again, we had a question, a long question, but the gist of it is how does one, a private fund advisor, private equity, figure out whether or not the disclosure that they have on fees and expenses, is it enough? Is it sufficient? You know, anything from the IM perspective that you can share generally about how an advisor to private funds should think about disclosure in the ADV with respect to fees and expenses.
Sure. So, so disclosure in Form ADV Part 2 should include information that a reasonable investor would need to know to make an informed investment decision.
Right.
The Form ADV disclosure obligation works in concert with an advisor's fiduciary duty obligation, and we would encourage advisors to read the Commission's interpretation regarding standard of conduct for investment advisors. When completing Form ADV, we would recommend that advisors ask themselves, have I accurately described fees and expenses? If an investor cannot determine the magnitude for a certain expense, then perhaps exams or enforcement may say you have not accurately described the expense. And an advisor cannot obfuscate the importance of a fee or an expense in investor disclosure.
Right. Thank you for that. And Mike, what do you say? I'm sure you have, yeah. What do you say?
There's no way you can put everything in an ADV or PPM because first, temporally, that tends the PPM tends to be at the beginning, particularly in say a private equity style where it's a drawdown, but even in hedge fund where it's continually offered. So I always start with the 2019 interpretive guidance, and there are essentially three elements. You can argue about which takes priority, but that's disclosure, eliminating conflicts, or mitigating conflicts. And so you have to look at it holistically. What's in the best interest of investors? It's not in the best interest of investors to rerun a ADV every month when you have new conflicted expenses. It just doesn't make sense. It also doesn't make sense on an ADV level to say you may do this when you know you are doing it.
Right.
So I think best practice is the ADV should be updated annually. If you're doing stuff, don't say I may do it, say we are doing things. But then the ecosystem in a private fund is different from retail. And that is because that institutional investors tend to have a much more robust due diligence process. And so I think where best practice is to have the broad principles, and if there's something significantly material with that specificity in ADV PPMs, but then in DDQs, due diligence questionnaires, which tend to be updated on a quarterly basis, sometimes semi-annually or annually, have more detail there. Your private funds, by and large, to comply with custody, almost always have an audited financial. And look at the financial statements. One thing that drives me crazy is that general counsels or compliance never looking at the footnotes in financial statements, right? Because that represents the firm, and that is a disclosure. From my view, that's a disclosure.
And we certainly look at them.
100%.
Yeah.
And so when you do the annual review, the legal and compliance should be looking at them. And if they're material elements, they will be included by the auditors. And that, by definition, or by compliance with the custody rule, the annual audited financial statements go to investors, and they should have disclosure in there with conflicts of interest, with related parties. But there's no way you can do that at a PPM and ADV level because it's not robust enough, and it's not ongoing enough in terms of keeping it updated.
Right.
Can I jump in?
Yeah, please, absolutely.
Mike, the reference to the May disclosures is something that
near and dear. Yes.
It keeps us in enforcement up at night. Certainly in conflicts cases, we are looking for those May disclosures when something is in fact happening. It was a small case that came out, I think, in September, but the Macellum Advisors case is a great example. You have outside third parties with consulting agreements, revenue streams, investing in activist campaigns alongside your private funds, and you have May disclosures. That's the kind of thing that we get exams referrals on all the time. We turn around and speak with our colleagues in IM, and we're on all fours that it's a real problem.
Yeah, that's a great segue into anything that enforcement would like to share on conflicts of interest related to fees and expenses.
Sure, yeah, and certainly, like you made the point earlier, Jen, like our fee and expense cases are typically coming from excellent referrals from exams. We're looking at it, we're talking about it with our industry experts, both in the asset management unit, in enforcement, in exams, and then our colleagues in IM to get a gut check, typically before coming out to you at all in the compliance community, to make sure we're on all fours about a violation. In fee and expense cases, enforcement, our goal is not to second guess or rewrite contracts that are negotiated by highly sophisticated parties. Our goal is to understand what they say and to make sure that a registrant is doing what they say they were going to do when it comes to charging fees, allocating expenses. So sort of two cases to highlight, the first on the fee side and the second more on the expense side, but both really conflict cases are the Insight Venture Management case from June of last year. There are two components to that case to kind of highlight. The first is the SEC's order found that Insight charged excess management fees. How'd they do that? The documents, the LPAs, identified the need to calculate expenses after a reduction for a permanent impairment, which I'll come back to later, at the portfolio company level, as opposed to the portfolio investment level. Okay, so that distinction between the portfolio company and the portfolio investment level can be material.
Yes.
And can result in excess fees. And here, this was the case where the SEC's order found that Insight's document said one thing and it did the other. I think the other takeaway and sort of focus of that case, which is a bit more nuanced, is a conflicts issue. In the Insight case, the SEC's order found that Insight did not disclose a conflict related to its permanent impairment criteria. So how did it decide when an asset was permanently impaired? The order found that Insight used criteria, which it did not disclose, that were so narrow and subjective that resulted in effectively very few assets ever being written down to a permanent impairment, which the SEC's order found was a disclosable conflict. So, the takeaway here is really to think about what an advisor or a registrant is doing as it relates to the permanent impairment issue and the fee calculation, and whether that rises to the level of disclosable conflict. And if so, what do your documents say about it? I think the second sort of expense case that I have is the Colony Capital case from September of 2024, so just last month or 2 months ago. So in that case, the SEC's order found that Colony breached its fiduciary duty by failing to follow certain contractually agreed provisions governing the timely disclosure of and consent to expenses that Colony allocated to a series of private real estate funds that it managed. The expenses were being paid, the order finds, by Colony affiliates. And the affiliates were providing services, and the funds were making payments back to Colony as a result, but it gave rise to a disclosable clear conflict. The LPAs in Colony sort of generally just required, as many LPAs do, that these kinds of transactions must be fully disclosed in writing to LPs and to LPACs and consented to. So I think the takeaway here is that if there is going to be cost shifting to affiliates of an advisor, you really have to think about whether or not that cost shifting is disclosed. Again, both Insight and Colony really important for purposes of the cooperation remediation point, which I made earlier. Incredibly important to enforcement.
So like my mother said, say what you do what you say.
Exactly, exactly.
Yeah.
Yeah, so on an ad hoc basis, with the 5 minutes that we have left, you made reference to how enforcement may take actions, and at times they are made from referrals from exams. Certainly in PFU, we make referrals to enforcement. But that is, one example of how our two divisions, work together, if you would. But from your perspective, can you talk a little bit about, collaboration? Certainly, Adele, exams is a customer of, IM, making sure that we interpret the rule. We have our regulatory counsel, Shane, who did a detail on IM,
Yes.
which made him even more valuable to his role in exams and in PFU advising us. But I know there's collaboration and a partnership with IM as well, with all of our reg counsel. So what do you think, Lee?
Yeah,
I know people often ask us when we're in the field, how do you work with exams? How, we hear that a lot.
Yeah, I mean, enforcement's a customer of everyone at the SEC.
Right.
We
Right.
need to make sure we're learning what there is to be learned from every division, and making sure that our investigations are focused and that we're not wasting our time and we're not wasting your time. But in terms of exams in particular, a referral is never just like a clean handoff.
Right.
Right. I mean, we get a referral, we try to understand it. We're in constant dialogue with examiners over time to make sure we understand it, to make sure that we understand the color behind it, and to understand sort of as we go through an investigation and learn new facts, how does that comport with the examiner's experiences during the exam?
Right.
So it's collaborative. And with IM, it's the same thing. We're always getting a consult early and often on the core theory. We're bringing the facts to IM as well to make sure that as we move along the process of potentially making a recommendation, that there are no surprises.
Right. And a referral from exams does not necessarily mean that enforcement will take an action and or that IM will agree with said action, right?
100% sure. We've there are plenty of referrals that don't end in enforcement actions. Right. And that doesn't mean that the referral wasn't sort of well made and that enforcement's investigation was well taken. So I think it really depends. And we think about, certainly in the context of an enforcement action, what happened in the exam?
Correct.
I would say.
Right.
The question comes to us is, well, is this enforcement worthy or not? I think one thing we think about is, was there remediation during the exam?
Right.
Monetary or otherwise? Were policies and procedures updated?
Right.
Is this an issue that has been taken seriously and that there's sort of a proactive path?
Right. Yeah. Mike, your views on what you see from, your experience and how divisions work together? Anything you want to add from the industry side?
Sometimes there's a view in the building that people just should do the right thing. From an industry perspective, sometimes the issue is there isn't a clear right answer. Sometimes you need to do the least bad answer. So I'll give you an example. A few years ago, when I was at a multi-manager fund, GAAP changed the rules. And so if you held a public security that was restricted in some way, but it was the same class of a publicly listed security, you couldn't take a discount. And we had taken a 10% liquidity discount because we knew if we dumped the whole position, it would affect the price.
Right.
So it could have looked like we were inflating the value to get fees. But our investors wanted a clean GAAP opinion. They did not want us to take an exception to GAAP because they couldn't then invest. So what we ended up doing is taking off the haircut. So we had an artificial increase in the value. And at that stage, then I put a footnote in the financials as to why we did it. Right. Or second example is that sometimes I've had PMs or founders tell me, I want to be very conservative on valuation. So I want to take the lowest valuation that comes out. Well, in certain circumstances, it's not about inflating the price to get a better fee. Say you have an investor redeeming and insiders or affiliates subscribing, it may be beneficial to the insiders from subscribing to have a lower valuation because that it could increase. So with all this stuff, from my perspective, it's you have to understand what the rules are, but then you have to apply them. And if you apply them in putting the investors in interest first, you're almost always going to be better able to get the right answer, but then document why you did it so that if it goes to enforcement or exams, they understand why you've taken a particular action.
Yeah, that's great. Thank you so much.
One other item,
Yeah.
as far as collaboration, IM definitely relies on what exams is seeing to help inform
Right.
rulemaking and better serve the
Yeah.
overall market.
Absolutely. So thank you so much, really, for all of your candid responses and participation. And Mike, you particularly joining us from industry. We appreciate you coming down to our offices today. And Shane, thank you for being available from Philadelphia. Thank you to the audience. We hope you benefited from our conversation and enjoy the rest of the activities today with the outreach. Have a good one, everybody. Thank you.
Okay. Well, thank you so much, Jen. And thank you to all the panelists for that extremely helpful discussion on topics of interest for private funds. And again, how the divisions coordinate with each other. So thank you all for that lively discussion. We turn our attention now to our fourth panel, which will cover the always popular topic for us, the marketing rule. This discussion will include general prohibitions, policies and procedures, the marketing rule's impact on the solicitor's rule, testimonials, endorsements, performance advertising, along with enforcement's perspective on the marketing rule. While our panelists are assembling here, I will introduce our moderator, Karen Stevenson, who is a senior program advisor for the National Examination Program Office. And also, I'll just say, instrumental in putting on this seminar, along with the rest of our national examination team. Karen will lead the panelists through this topic. And so with that, I turn it over to you, Karen, to begin the discussion.
Thank you, Vanessa, for the introduction. Good afternoon, everyone, and thank you all for joining us today for what I believe will be a thought-provoking and helpful discussion about the marketing rule requirements for investment advisors. Given that it has been 2 years since the compliance date of the marketing rule, I think you'll find that our panelists, who have a breadth of knowledge on this subject, will have a great deal of interesting information to share with you. I'd like to welcome all of our panelists here today and provide brief introductions. Joining us from the Division of Examinations is Melissa Harkey. Melissa is a senior counsel in the Division of Examinations Office of Chief Counsel. Melissa was previously in the Division of Investment Management, and she led the team that drafted the proposal and adoption of the marketing rule. And now, in the Division of Exams, she works with a team to ensure consistent application of the rule. And joining us from the Division of Enforcement is Brianna Rifa. Brianna is an Assistant Director in the Division of Enforcement's Asset Management Unit. Brianna led the team that launched the Marketing Rule Enforcement Initiative, has supervised more than 20 Marketing Rule enforcement actions. Joining us from the Division of Investment Management is Scott Jameson. Scott is Senior Counsel in the Division of Investment Management and is part of the Marketing Rule implementation team in this division. This team tackles interpretive questions on the Marketing Rule and prepares staff guidance, including the Marketing Rule FAQs. And finally, joining us from the CFA Institute is Karen Vincent. Karen is Senior Head, Global Industry Standards and GIPS Executive Director at the CFA Institute. Karen has devoted much of her time over the past years addressing marketing rule requirements, given both the overlap of the GIPS standards and the performance requirements of the marketing rule, as well as the differences between the two. Thank you, Melissa, Brianna, Scott, and Karen for joining us today. Now, the goal of today's discussion, aside from hopefully avoiding technical difficulties, is to provide some useful information to improve compliance with the marketing rule and to provide perspective on various issues or challenges observed over the last couple of years. We collected questions ahead of time and tried to incorporate these into today's discussion. Now, before we dive into the details of the various components of the marketing rule, we will start with a discussion of what practices or activities meet the definition of an advertisement. We then plan to, as Vanessa mentioned, cover the general prohibitions, performance advertising, including hypothetical performance, testimonials and endorsements, and third-party ratings. Scott, could you start the discussion about the definition of an advertisement, including what would not be considered an advertisement?
Sure, Karen, and thank you for the introduction. So the definition of advertisement in the marketing rule has two prongs. The first prong deals with offers of advisory services. It includes any direct or indirect communication made to more than one person, or if the communication includes hypothetical performance, to one or more persons that offers advisory services to prospective clients or investors. And there are a few exceptions that we'll discuss. The second prong of the definition of advertisement includes any endorsement or testimonial for which an advisor provides compensation directly or indirectly. For both prongs of the definition, there is an exception for information that is contained in a regulatory filing or other required communication. An example of this would be Form 8EV. The first prong of the definition, dealing with offers of advisory services, also includes exceptions for extemporaneous live oral communications and a communication that includes hypothetical performance that is either included in a response to an unsolicited request or is provided to a prospective or current investor in a private fund advised by the investment advisor in a one-on-one communication.
And so can you talk a little bit about different types of advertisements? Like, for example, are all advisor websites advertisements? What about pitch books? And then also, what about brand content, general education material, and market commentary?
Yeah, so whether a communication meets the definition of advertisement depends on all the facts and circumstances. Things like pitch books, websites, they generally fit the paradigm of an offer of advisory services, and we would expect them to be covered by the definition in most circumstances. On the other hand, communications that do not offer advisory services, such as brand content, general educational material, and market commentary, may not be advertisements. Determining whether an advertisement or communication is an advertisement requires careful consideration. It's not as simple as labeling material white paper or educational or market commentary. It has to be a substantively not an offer of advisory services. So just as a few examples, market commentary that continues on to include a description of how an advisor could help prospective clients deal with the market conditions, that could be an offer of advisory services. Furthermore, communications that include a compensated endorsement also generally are advertisements. And as we will cover later in this presentation, the definition of testimonial and endorsement can cover a number of different arrangements, from traditional placement agents and referral arrangements to social media influencers and TV advertisements. One important thing to note is that regardless of whether a communication is an advertisement, it'll be subject to the general anti-fraud provisions of Section 206 of the Advisors Act.
Thanks for making that point, Scott. Melissa, is there anything you'd like to add from an examination perspective? Could you speak to what you are seeing on exams in regards to advertisements that are not as obviously advertisements to some advisors as well?
Sure, I'd be glad to. Let me give you some examples of some of the trickier situations we're seeing. So the first one I would raise is stock material within a one-on-one presentation. There are two ways that this tends to come up. First, we have seen that some advisors try to get out of the definition of advertisement by customizing a template presentation or mass mailing by filling in the name of an investor and or including other basic information about the investor. But this would not be a communication to more than one person. Second, if hypo is not specifically tailored to the investor and the investor didn't request the information unsolicited, then it wouldn't meet the elements of the exception from the definition of advertisement in C2 of the definition, and that means it would be an ad. Another situation that we are seeing is in the context of private fund advisor websites. Some private equity fund advisor websites in particular may be designed in a way to attract both prospective investors and prospective portfolio companies in which to invest its funds. And it may be hard to distinguish the intended audience and the type of services it is promoting. Figuring out the intended audience, however, is important when it comes to determining if something is an advertisement for purposes of the marketing rule. Where it is unclear, we generally presume that such a website is an advertisement offering advisory services to prospective investors, which would be subject to the rule, but we would consider whether the advisor has sought to direct its various audiences to particular content. So for example, an advisor may have a homepage that clearly directs investors and prospective investors to one part of the site, while it directs prospective portfolio companies to another part of the site. And a final example that I'll provide, as Scott noted a moment ago, and I would also like to remind folks that the rule applies in the context of solicitors. That could be the old school solicitor who meets with prospective clients over a steak dinner or placement agents for private fund shares, but it can also be newer types of promoters like social media influencers, networking arrangements, expert networks, lead generation firms, refer a friend programs. They take various forms. They've got lots of different titles and names, but they tend to fall in the category of testimonials or endorsements. Testimonials or endorsements, as Scott mentioned, they include opinions or statements by a person about the investment advisory expertise or capability of the advisor or its supervised persons. Testimonials and endorsements also include statements about an advisor or its supervised person's qualities. So for example, trustworthiness, diligence, judgment, or expertise or capabilities in other contexts, when the statement suggests that the qualities, capabilities, or expertise are relevant to the advertised investment advisory services.
Melissa, could you also speak to the circumstances in which third-party content may be attributable to an advisor?
Whether third-party information is attributable to the advisor will require an analysis of facts and circumstances. So first, you'd want to determine whether the advisor has explicitly or implicitly endorsed or approved the information after its publication. That would be adoption. Or the extent to which the advisor has involved itself in the preparation of the information. And that would be entanglement. An advisor is liable for the third-party content under the marketing rule, just as it would be liable for the content it produced itself in those circumstances.
Okay, so can we talk about an example of where an advisor might comment on a post of a review located on a third-party site? Are there circumstances in which that may become attributable to the advisor?
That's a good question, and it depends. So generally, no. But if the advisor provides the language for a client to paste into the comment feed, or gives clients, for example, gift cards, as we saw in one particular, well, a few different exams, for writing third-party site reviews, that would be entanglement. So, or if the advisor links to third-party site from its own site, that would be adoption. And then in those circumstances, that content would be attributable to the advisor in the same way that it is if the advisor prepared it itself, and it must comply with the rule. The reverse factual scenario requires a similar facts and circumstances analysis, by the way. So whether content posted by third parties on the advisor's own website is attributable to the advisor depends on the advisor's involvement, such as whether the advisor selectively deletes or alters the content, or if the advisor comments on reviews on other websites more than just liking. The commission doesn't view an advisor's edits to existing third-party communications to result in attribution. However, if the advisor edits a third-party communication based on pre-established objective criteria that are documented in the advisor's policies and procedures and are not designed to favor or disfavor the advisor. So this would be like editing to remove profanity, defamatory offensive statements, et cetera.
Okay, thank you. And continuing with Scott and Melissa, can we talk a little bit about social media? We received some questions about this. It seems pretty obvious that an advisor's business social media accounts would be considered an advertisement, but under what circumstances, if any, would advisory personnel's personal social media accounts become advertisements of the advisor?
Sure. So there are certainly facts and circumstances where a personal social media account of an employee of an advisor could post or share or frankly be an advertisement for the advisor. And really our concerns here are circumstances where it's difficult for prospective investors or clients to differentiate whether the communication is coming from the employee in his or her personal capacity or if it's made in their employment capacity on behalf of the advisor. That being said, the Commission has stated that if the advisor adopts and implements policies and procedures reasonably designed to prevent the use of an employee social media account to market the advisor's advisory services, we generally would not view communications made in violation of such policies to be a communication made by the advisor. One thing to note, however, in these cases is that these policies are protective of the advisory firm. They don't necessarily extend that protection to the employee making the communications, and they still could be held responsible if they violate the rule.
Okay.
Melissa, do you want to speak a bit on what level of oversight and record keeping is required here?
Sure. Yeah, some things an advisor might consider would be conducting periodic training, obtaining attestations, periodically reviewing content that's publicly available on associated persons' social media accounts. And then, of course, maintaining records of these steps would readily demonstrate that the advisor is making efforts at complying.
Great, thank you both for that. Now, let's turn to the general prohibitions. While we will be discussing the general prohibitions throughout the panel today, I'd like to briefly touch on them, and in particular, substantiation. Now, Brianna, could you start this discussion by telling us about the recent enforcement cases that involve the general prohibitions?
Yeah, there have been a number of these types of cases in recent months, and I'll be talking about some of them later in today's panel, but just to highlight a couple right now, in March, we charged two firms, Global Predictions and Delphia, with violating, among other things, the first general prohibition. So this is found at subpart A1 of the rule, and that first general prohibition prohibits any untrue statement of material fact. And we charge these firms for making claims on their public websites about their use of AI that were not true. In September, we also announced a settled action with an advisor that also violated that same first general prohibition, A1, because that advisor had advertised on its website that it was a member of a fictitious organization called Fiduciary Firm, and it had a logo for that fictitious organization, which did not exist. So again, untrue statement of material fact in an advertisement. We also charged that same firm, as well as three others at the same time, for violating another one of the general prohibitions, the second general prohibition found at subpart A2, and that prohibits making any material statement of fact in an advertisement that an advisor does not have a reasonable basis for believing it will be able to substantiate upon demand by the commission. So these 4 advisors were disseminating ads on their websites stating that they provided conflict-free advisory services when their ADV brochures, meanwhile, disclosed multiple conflicts. And so thus they weren't able to substantiate or reasonably believe that they could substantiate those claims of being conflict-free.
Thanks, Brianna. And Melissa, could you speak to substantiation and the types of statements within advertisements for which exam staff typically request substantiation? And if you can, speak to any best practices in determining when something becomes a material fact?
Sure, happy to. First, remember, as Brianna pointed out a moment ago, the requirement is not to substantiate every material claim or statement. The requirement is to have a reasonable basis for believing it will be able to substantiate material statements of fact as opposed to opinion. And as for best practices, some advisors maintain records or substantiate non-performance material statements of fact included in an advertisement at the time of dissemination. Performance, of course, must be substantiated in the advisor's records, as my colleague noted a moment ago on the previous panel. The second thing is to bear in mind that the test for materiality here is the same as elsewhere in the federal securities laws. So you're looking at it through the eyes of a reasonable investor. Through that lens, information is material if there's a substantial likelihood that the disclosure of the omitted fact would have been viewed by the reasonable investor as having significantly altered the total mix of information made available.
Okay, so what are the expectations for substantiation when an advisor advertises products that are actually managed by other investment advisors or advertise the performance of third-party products?
Great question. If you recall what we discussed earlier about adoption and entanglement, here the advisor has adopted third-party content. The advisor would be liable for the content just as it would be if the advisor produced the content itself. And as a result, then they are subject to the rule with respect to that content, and substantiation, in this case, is on the table.
And one last question, Melissa. Have you identified any common findings where advisors lacked adequate substantiation?
Sure. Certainly situations similar to what Brianna mentioned shortly ago. Also, a few others I'll mention, advisors that stated that certain services were unique when they were, in fact, very common. Advisors that made untrue statements about their staff numbers or credentials. Untrue statements about awards and accolades, and then, as my colleague on the prior panel mentioned, performance statements as well.
Great, thank you. Thanks, Brianna, as well. Now we're going to turn to the big topic of performance. We received a number of questions related to what should be considered performance advertising versus what would be considered a portfolio characteristic. Now, Karen, could you start by discussing what you are seeing in the industry related to portfolio characteristics or performance metrics, such as contribution to return, attribution effects, or yield in marketing materials? Are advisors treating these as performance? What challenges are they encountering?
Determining what's considered performance, which must be presented on a net basis, continues to be a challenge. Earlier this year, we conducted a survey with the Investment Advisor Association, or IAA, where we asked firms about the policies they were following for complying with the marketing rule. We asked what has been the biggest challenge with implementing the marketing rule, and the top response was determining what is considered performance. Given the uncertainty around what is considered performance, as well as the difficulty or inability to calculate net versions of some of these performance metrics, we know that many firms have stopped including contribution, attribution effects, and yield in marketing materials. Numerous survey respondents also told us this. In the survey, we asked those firms that do include these items in marketing materials whether they treat them as performance. Of those firms that do include these items in their marketing materials, the results were very similar for the 3 items. The results were almost evenly split, with half of the firms treating either attribution effects, contribution, or yield as performance, while the other half did not. The survey report is on the GIPS website, which is gipsstandards.org.
Great, thank you, Karen. And Scott, is there anything you could add regarding what should be considered to be performance in advertisements?
Sure, Karen. So we recognize that these can be challenging questions and that advisors want to get it right. The rule does not adopt a definition of performance, in part because performance can take many forms, depending on the strategy and how the advisor is marketing itself. That said, we generally think of performance in a dollar and cents way. Can an investor use this figure to figure out how much money they will take home? So for example, annualized return, that's obviously performance, as is IRR. On the other hand, performance derived statistics, such as the Sharpe ratio or attribution effects, generally, we have not viewed those as performance. Yield is a tricky one, and we've gotten a lot of questions about yield, in part because it can be used to measure many different types of characteristics, and how it will be used will likely affect whether it is considered performance or not. For example, in some strategies, such as fixed income or money market strategies, yield can be the primary metric of the advisor's success. And then we would likely view it as performance. In other cases, if you're showing the dividend yield of an equity security held in the portfolio as part of a constellation of other information about that security, it may be a characteristic that isn't performance. In part, an advisor wrestling with the question of whether or not something is performance should ask themselves, why am I showing this? If it's to show how successful you've been in managing the portfolio for your clients, it's more likely to be performance.
Great, thank you for that insight. So turning to some of the specific requirements related to advertising performance, Scott, could you address the requirement to present net performance with any presentation of gross performance, and how actual or model fees for the net calculation, as well as the intended audience for the advertisement, impact such presentations?
Sure. So the marketing rule requires gross performance to be accompanied by net performance. And the net performance must be presented with at least equal prominence to, and in a manner designed to facilitate comparison with, the gross performance. And the net performance must be calculated over the same time period and using the same type of return and methodology as the gross performance. For these purposes, net performance is defined as the performance results of a portfolio or portions of a portfolio included in extracted performance, if applicable, after the deduction of all fees and expenses that a client or investor has paid or would have paid in connection with the investment advisory services. Net performance may reflect the exclusion of custodian fees paid to a bank or other third-party organization for safekeeping of the funds, and it also may reflect the deduction of model fees. However, if you're using model fees, they must reflect one of the following: the deduction of a model fee that results in performance figures that are no higher than if the actual fee had been deducted, or the deduction of a model fee that is equal to the highest fee charged to the intended audience to whom the audience or the advertisement will be disseminated. While the definition of net performance does not require using model fees, there may be circumstances where, based on the intended audience of an advertisement, an advisor should use model fees in order to comply with the general prohibitions that we referenced earlier. There's a recent enforcement case regarding performance advertising that violated some of these provisions. Brianna, can you tell us about that one?
Yeah, so in April, we charged the firm Diasphere with a number of different marketing rule violations, in fact, including many of the provisions we're discussing here today. So it's a good case to look at generally for an illustration of how a variety of these violations can come into play. But one of the violations was that Geosphere advertised certain fact sheets on its public website that presented gross performance without also presenting that net performance. So that was in violation of subpart D1 of the rule, which you just described. Geosphere was also unable to produce records substantiating the performance shown in the fact sheets, as well as some other claims it made about performance. And so that was also in violation of the general prohibition A2 requiring substantiation.
Thanks. And Scott, what should advisors consider regarding the general prohibitions, particularly as it relates to model fees?
Yeah, so as Brianna just highlighted, it's important to remember that the general prohibitions apply to everything in an advertisement, including performance. There are additional requirements under the marketing rule for performance, but this does not mean that the general prohibitions no longer apply. They do. In the context of model fees, the Commission has specifically stated that if the fee to be charged to the intended audience is anticipated to be higher than the actual fees charged, the advisor must use a model fee that reflects the anticipated fees to be charged in order not to violate the rule's general prohibitions. The Commission has also stated when using model fees that advisors must use the higher of the highest fee that was charged historically or the highest potential fee that it will charge the investors or clients receiving the particular advertisement.
Okay, so can we next run through some examples we received from the audience? Scott, how should a firm determine an appropriate model fee for a composite that includes a mix of accounts paying different fees according to a tiered fee schedule?
Yeah, so if the composite will be used to market accounts for in each tier of the fee schedule, if there's no differentiation between the intended audience here, the intended audience would include investors paying the highest fee. Accordingly, it would be appropriate for the net performance of the composite to reflect the deduction of a model fee that equals the higher of the highest fee in the fee schedule or the highest fee that was charged historically. One thing to note here is that the marketing rule does not prohibit including additional calculations of performance using different model fees. For example, you could potentially show net performance using model fees that equal each tier of the fee schedule, provided that the net performance requirements of the rule are satisfied and there's adequate disclosure in order to address the general prohibitions here. However, solely presenting net performance for the for the composite calculated using a lower T fee in the fee schedule would likely be misleading under the general prohibitions.
So, Scott, again, if an advisor uses model fees in its calculation of composite performance, and then the advisor changes its fee schedule to increase its fees, does the historical composite performance need to be recalculated?
So generally, yes. In these circumstances, an advisor would need to include net performance calculated using a model fee that is equal to the highest fee in the new fee step structure. The intended audience of these advertisements are clients and investors that would pay the new fee structure. And accordingly, under the general prohibitions, the Commission has stated it would be misleading to present net performance using a model fee that is not available to the intended audience.
Great, thank you. Now turning to Karen, could you speak to what you are seeing in the industry related to the calculation of net returns, including any challenges you are seeing?
So the first challenge is determining whether to use actual or model fees. As Scott described, the rule states that a firm can use either. However, the language within the adopting release, including everyone's favorite footnote, number 590, provides what some would say is contradictory guidance. And it also seems to negate the ability to use actual fees to calculate net returns. Footnote 590 says that if the fee to be charged to the intended audience is anticipated to be higher than the actual fees charged, the advisor must use a model fee that reflects the anticipated fee to be charged in order to not violate the rule's general prohibitions. But even if a firm has had the same fee schedule for its history, given the widespread use of tiered fee schedules, the historical effective fee rate will almost always be lower than the top tier of the proposed fee schedule, and a firm would have no way to know how much money a new client would have to invest. So firms often assume that the prospect would pay the top tier of the fee schedule, which of course would be higher than the effective actual fee rate. So the firm then feels forced to use a model fee. And the second challenge is determining which model fee to use. The first model fee option in the rule, which allows net returns to be calculated using a model fee that generates net returns that are equal to or lower than returns that would have been calculated if actual fees had been deducted, seems straightforward. And the adopting release has language supporting this approach, which says that if an advisor advertises net performance that is no higher than if deducting actual fees, there appears to be little chance of misleading the audience into believing that investors received better returns than they actually did. However, the adopting release then goes on to state that the model fee must be the higher of the highest fee that was charged historically, or the highest potential fee that it will charge investors. So a firm could be forced to apply as a model fee a fee that was used historically that is not relevant to prospective clients. And this would contradict footnote 590, which says the advisor must use a model fee that reflects the anticipated fee to be charged in order not to violate the rule's general prohibitions. And a final challenge here is determining what was the highest fee charged historically. Does this mean what was the highest tier of a fee schedule at any point in time? Does it mean the effective fee rate of an individual portfolio or of a composite at any point in time? And also, how do performance fees factor in here? So given this language, if one account in the composite paid a performance fee, a firm could believe it needs to apply a model fee with a performance component when it's not intending to charge a performance fee. So firms are taking different approaches here. First, according to our survey, a majority of firms are using model fees and not actual fees. A common practice is to use as the model fee the highest tier of the applicable fee schedule. So if the fee schedule starts at 100 basis points and ratchets down to 50 basis points as assets increase, the model fee is a flat 1%. But if the fee schedule has changed over time, some firms will use as the model fee the highest tier of the fee schedule in effect for the respective period. So if the highest fee used to be 1% and it was changed to 75 basis points, the firm would apply a 1% fee for the period for which the 1% fee was in effect, because that was the highest fee that was charged historically, and then change to the new fee schedule of 75 basis points going forward. Some firms would apply the 100 basis points for all periods because that's the highest fee that was charged historically, while others apply the 75 basis points for all periods because that's the proposed fee schedule. Another approach would be, as Scott mentioned earlier, to include multiple net return streams. Using the same example, a firm might include net returns calculating a 1% model fee, as well as net returns calculated using a model fee of 75 basis points. And they might include net returns calculated using actual fees too. Firms want to be able to standardize their marketing materials and not need to tailor them to each prospect, so including multiple net return streams might be a good approach. Of course, whichever approach a firm takes, it needs to carefully document its rationale for using actual or model fees and choosing a model fee.
Thank you, Karen. And now turning to performance time periods, the 1, 5, 10-year requirements for performance advertising. Karen, could you start by discussing any challenges you're seeing in the industry related to the required time periods for performance advertisements?
So when portfolio or composite performance is shown, a firm must include performance for 1, 5, and 10-year periods. And these prescribed time periods must end on a date that is no less recent than the most recent calendar year end. Firms struggle with determining where these prescribed time periods must be presented in marketing materials. particularly in pitch books where composite or portfolio performance is shown in multiple places. So Scott, can you tell us where those prescribed time periods must be shown?
Sure. So as an opening matter, the required time periods do not apply to the performance results of private funds. So all of this discussion we're about to have, just keep in mind that this does not apply to the performance of private funds, and we're focusing on other types of portfolios. For these types of portfolios, the rule simply requires that advertisements that show performance include performance for the 1, 5, and 10-year periods, and that each of those time periods is presented with equal prominence. The general prohibitions, however, prohibit presenting performance time periods in a manner that is not fair and balanced. So in selecting time periods for performance of an advertisement, an advisor may not select the periods that show only the most favorable performance results. Advisors should be careful not to cherry pick periods of high performance to display prominently in an advertisement.
And do those prescribed time periods need to be on each page of the marketing materials?
So the rule does not explicitly require showing performance for the required time periods on each page of a flip book or other set of marketing materials. So absent rare circumstances where it would be necessary to avoid presenting time periods in a manner that is not fair and balanced, you don't need to include them on each page.
And can those prescribed time periods be in a footnote or endnotes at the back of the presentation?
So putting the performance over the required time periods in a footnote or endnote potentially could be permissible under the rule, but advisors should be cognizant of whether the presentation remains fair and balanced or whether the presentation is otherwise material and misleading if these time periods are in a footnote or an endnote. Cherry picking, again, of periods of high performance in a manner that is not fair and balanced to display prominently could violate the general prohibitions.
And one last question. Do the prescribed time periods need to be shown for each type of performance that is shown?
So yes, the Commission has clarified that the time period requirements applies to all performance results, including net and gross performance, and including any composite aggregation of related portfolios.
Great. Thank you, Karen and Scott. Now we're going to move on to hypothetical performance specifically. Brianna, could you begin the discussion with enforcement sweep related to hypothetical performance?
Yeah, sure. So just to level set at the outset, hypothetical performance is defined in the rule as performance results that were not actually achieved by any portfolio of the investment advisor. And that includes, but is not limited to, model performance, back-tested performance, and targeted or projected performance returns. And this portion of the marketing rule is premised on the idea that hypothetical performance has a high potential to mislead at least certain audiences of investors. And so the intent of the rule is that advertisements of hypothetical performance are only distributed to investors who have access to the resources to independently analyze this information and who have the expertise to understand the risks and limitations of these types of presentations. So to this end, the rule prohibits RIAs from including any hypothetical performance in their advertisements unless, among other things, they adopt and implement policies and procedures reasonably designed to ensure that the performance is relevant to the likely financial situation and investment objectives of the intended audience for the ad. And in adopting this requirement, the Commission observed that it believes advisors generally wouldn't be able to include hypothetical performance in advertisements directed to a mass audience or intended for general circulation, because in that case, the advertisement, being available to a mass audience, the advisor generally wouldn't be able to form any expectation about that mass audience's financial situation or investment objectives. So notwithstanding that note in the adopting release, enforcement and exams have identified numerous advisors that were advertising hypothetical performance to mass audiences on their public websites without adopting, let alone implementing sufficient policies and procedures to ensure that that hypothetical performance was relevant to the likely financial situation and investment objectives of the intended audience, which again, when you're talking about a public website, it could be anyone who views that website. So from August of last year through just last week, we've settled with about 18 firms for violating this provision of the marketing rule. And in virtually all of those settlements, we found that the advisors really didn't have any kind of meaningful policies or procedures that would identify an intended audience for hypothetical performance or outline how they would determine that the hypothetical performance is relevant to that audience.
Thank you, Brianna. Scott, could you discuss how firms should approach determining who can receive hypothetical performance? And then Karen, how firms are typically making this determination?
So as Brianna mentioned, the commission has stated that advisors generally would not be able to include hypothetical performance in advertisements directed to a mass audience or for general circulation. Accordingly, an advisor's policies and procedures could address how the advisor's dissemination of the advertisement would seek to be limited to an appropriate audience. For example, such policies could distinguish investors types on the basis of criteria, such as previous investments with the advisor, net worth, investing experience, if that information is available to the advisor, certain regulatory defined categories such as qualified purchasers or qualified clients, or whether the intended audience includes natural persons or institutions, especially if it's limited to one of those. For an example, an advisor, based on its past experience, might be able to reasonably conclude that hypothetical performance would be relevant to investors who meet financial sophistication standards such as the qualified client standard or the qualified purchaser standard. The advisor's policies and procedures could explain why it believes that hypothetical performance is relevant for the intended audience. Karen, can you talk a bit about what you're seeing firms do from your side?
So in our survey with IAA, we included questions about hypothetical performance. Many firms told us they've stopped including any hypothetical performance in their marketing materials. But for those firms that are including hypothetical performance, the most common qualification for receiving this information is to be an institutional investor as defined in a firm's policies and procedures, including being a qualified institutional buyer or an accredited investor. Some firms also qualify all financial professionals as proper recipients of hypothetical performance. But firms also have different policies for when this information is provided, which is usually done only in one-on-one meetings.
Thank you. And Melissa, what issues have been identified on exams in relation to hypothetical performance?
Sure, I'd be happy to cover that. Performance comes up a lot on exams, hypothetical performance in particular. One aspect of the types of deficiencies we were seeing is really just missing the issue entirely, especially in the case of targets and projections. Otherwise, failing to comply with any of the requirements of the rule. I won't get into that, as my colleague on the last panel covered that pretty extensively. Also, advisors mistakenly believing that using the same materials with multiple investors would qualify for the exception from the definition of advertisement if the advisor presents it in a one-on-one setting. And this we discussed earlier on the panel. And then last, I would mention some issues that arise in the context of the exception for interactive analysis tools. So if you recall, this part of the rule is it's a tool to produce simulations and statistical analyses that present the likelihood of various investment outcomes if certain investment strategies or styles are undertaken. And there are four criteria for this exception to apply. Some advisors have failed in this context to take into account specific information from the client, which would take them out of the exception. Other advisors, in their context, the clients weren't using the tool. And then also advisors made changes to the output from the tool. Those are some of the common ones we've seen. I would also add the third criterion also seems to trip up some advisors, where you're supposed to describe the universe of investments considered in the analysis and explain how the tool would determine which investments to select. So I think that one gets folks tripped up a bit too.
Great, thanks, Melissa. And I know we could talk about performance for the rest of the day, but turning to some of our other topics, can we now talk about testimonials and endorsements? Scott, could you first speak to the rule requirements for testimonials and endorsements, as well as the definitions, including how traditional solicitation arrangements fit into the definition of endorsement, and also the use of influencers in social media?
Sure. So the marketing rule includes requirements for marketing activities conducted by others on behalf of investment advisors. We broadly refer to these as testimonials and endorsements. And these requirements in the marketing rule replace the old cash solicitation rule that existed prior to the marketing rule's adoption. So there are three main requirements for testimonials and endorsements, and there are some exemptions from these requirements for certain types of testimonials and endorsements. And so the first requirement are there are certain required disclosures, and these include both clear and prominent disclosures and other disclosures that must accompany the testimonial and endorsement. The advisor must conduct oversight and maintain written agreements and make sure that the testimonials and endorsements comply with the rule, and these are generally referred to as the oversight and compliance requirements. And finally, there are some disqualification provisions where certain bad actors are not permitted to provide testimonials or endorsements in advertisements of advisors or be compensated for them. Taking a step back, however, it is important to define what is a testimonial or endorsement. So their definitions are pretty similar. The main key difference here is who provides the statement. A testimonial is a statement by a current client or investor, and the statement is either about the client or investor's experience with the advisor, or it directly or indirectly solicits clients or investors for the advisor, or it refers clients or investors to the advisor. An endorsement, on the other hand, is a statement made by a person other than a current client or investor. So this could be anyone else. And the three types of communications that are covered here are similar, but there are some differences with the first prong, where an endorsement covers any statement that indicates approval, support, or recommendation of the investment advisor, or that describes the experience with the advisor. It also includes communications that solicit or refer clients to the advisor. So these definitions can cover a number of different arrangements, as we've mentioned a few times in this discussion. Much of the focus of, I think, a lot of guidance and thinking around this has been on kind of the newer types of arrangements that are covered by the rules: social media influencers, TV advertisements, and various other types of new technologies that are allowing firms to reach people in new ways. But it's important to remember that these also include more traditional referral arrangements, as well as placement agents and other types of professional marketers. There are limited exceptions for registered broker-dealers, but these are not complete exceptions from all the testimonial and endorsement requirements. Certain requirements are likely to remain applicable, and so this is something that advisors really should consider when entering into these arrangements.
All All right, great. Thank you, Scott. And Brianna, what can you tell us about recent enforcement cases that included testimonials or endorsements?
So to date, we brought a handful of actions that involve violations of the testimonials and endorsements provisions. Earlier, I mentioned a case that we brought in March against Global Predictions. That was one of the firms that had made untrue claims about its use of AI. But another one of the violations in that case was also failing to disclose conflicts of interest resulting from its relationship with individuals giving testimonials, including 2 persons who gave testimonials that had outside business relationships with Global Predictions' CEO, and a 3rd person giving a testimonial who was a close family member of the CEO. So those relationships created conflicts of interest. Under the rule, they have to be disclosed. In the April action against Geosphere that I mentioned earlier, we also charged it with violations of the endorsement provisions because it had paid 2 unaffiliated accounting firms for endorsements to obtain clients through referrals. But Geosphere didn't have written agreements with either firm. So in my mind, this is a violation of the endorsement provisions that really more closely resembles violations of the prior cash solicitation rule. And then in September, we charged a firm that had directly and indirectly disseminated numerous advertisements containing an endorsement that the firm was the official wealth management partner of a specific university's athletic program. But those advertisements at times didn't include the required disclosure that the endorsement was given by a person other than a current client and that cash compensation was provided for the endorsement. Those endorsements appeared without the required disclosures on the public website of the athletic program and other third-party websites. The athletic programs and the advisor's own social media platforms, in online videos, and on physical objects that were distributed, such as bags and flags, as well as in an ad that was shown on the university's athletic arena jumbotron. Separately, that firm also disseminated an advertisement claiming to contain testimonials that didn't actually come from current clients. One purported testimonial came from someone who was no longer a client, and another came from someone that the firm couldn't verify had ever been a client. So those didn't actually meet the definition of testimonial, but the firm also didn't disclose that these were actually endorsements from non-clients. And then just last week, we settled with another firm that had disseminated advertisements on its website, on social media, and via direct email that included endorsements from professional athletes who were paid for the endorsements, as well as one professional athlete that had an ownership interest in the advisor's parent company. But the ads didn't disclose that these endorsements were from non-clients, that compensation was provided for the endorsements, or the conflict of interest that was created by that ownership interest that one of the athletes had in the firm's parent.
Great, thanks, Brianna. And Melissa, what issues are you seeing on exams for testimonials and endorsements, including any overlap with the general prohibitions?
Sure. This comes up, not surprisingly, quite a bit. I'd say first off, maybe identifying or categorizing, recognizing that something is a testimonial or endorsement. So a common finding that we've seen is advisors saying that they were featured by or featured in a particular news outlet or other third party to make it, paid advertisement appear to be an endorsement by that news outlet or third party. This would not be an endorsement, although because it's made to look like one, it would be citable as misleading under the first general prohibition. So there's definitely overlap between these and the general prohibitions. We've also observed some inconsistency with the rule in the context of following a third party's method versus having a third party's endorsement. So for example, a firm may display a third party's logo to indicate that they follow a particular investment philosophy, which doesn't sound like an endorsement. But then what if they have to pay the third party to display the logo and the third party confirms the advisor is following their investment philosophy or recommends them? Then it starts to look more like an endorsement. So there's some, issues with recognition and categorizing and then following the rule appropriately. Another commonly missed issue is the refer a friend or other networking arrangements, as we've mentioned multiple times at this point. Remembering that other aspects of the rule may also apply is also a common challenge. So, for example, a client's testimonial that gives performance information will need to comply with the applicable portions of the rule with respect to performance advertising, such as showing net performance. And it could also implicate the general prohibitions, particularly the ones that would come to mind for me in this example would be 1, 2, 5, and 6. Another challenge here is meeting the elements of the testimonials and endorsements part of the rule. So such things as making certain disclosures clearly and prominently. These were the ones that the commission wanted to have particular salience and impact. For example, we've seen some advisors that hyperlink to the disclosures that are supposed to be clear and prominent, which is not within the terms of the rule. Also failing to disclose the material terms of compensation arrangements. So for example, some advisors disclosed that promoters, including social media influencers, received a percentage of the advisory fees charged to the referred client, but did not disclose the actual percentage or range of those fees, and omitted certain information about referral bonuses that were paid based on the number of clients referred to the advisor. We've also seen advisors failing to make sure that the total compensation in a 12-month period stayed within the $1,000 de minimis limit if they were looking to rely on that exception. We've also seen advisors failing to ensure that affiliated promoters' status as affiliated was readily apparent. Making sure that advisors oversee third parties has been a habitual problem. For example, having policies and procedures may really help prevent the promoter or the solicitor or the endorser, whatever you want to call them, from going off script. And, this part of the rule applies even if if there is de minimis or no compensation. And then the last thing I would mention is we've seen some advisors that have, completely overlooked the fact that there's this disqualification provision within the rule, similar to what was in the cash solicitation rule, that if there is compensation above the de minimis amount, the advisor needs to exercise reasonable care to know if the person giving the testimonial or endorsement is an ineligible person at the time the testimonial or endorsement is disseminated.
Thank you. And is there anything you can speak to in regards to how advisors are addressing clear and prominent disclosures or layered disclosures, particularly in social media or on small screens, Melissa?
Sure. Yeah, actually, some advisors appear to be following the guidance in the release about layering and making disclosure effective on a small screen. There is discussion in the release that firms seem to be, taking to heart and following. Where we've had concerns in this space is, say, for instance, on a video that might be on viewable on a small screen like a cell phone, the video flashes so fast. It's up before the content, but it's so fast that you can't read it, or it's in an unreadable font because it's so incredibly small, or we've even seen them where the color of the disclosure is similar to the background, so you can't really, there's not enough contrast to be able to read it.
Great, thank you. Thanks, Melissa, Scott, and Brianna. Now moving on to our final topic for today's panel, which is third-party ratings. Scott, could you start with a discussion of the rule requirements for third-party ratings?
Sure. So the marketing rule requires a third-party rating for it to be used in an advertisement, and an advisor must have a reasonable basis for believing that any questionnaire or survey used in the preparation of the rating is structured to make it equally easy for a participant to provide a favorable or unfavorable response, and is not designed or prepared to produce any predetermined results. In addition, advisors must make certain disclosures related to the date of the rating, the party making the rating, and if applicable, any compensation paid in connection with the rating.
So Scott, in regards to the reasonable basis related to the structure of the survey or questionnaire, could you speak to the ways in which advisors could form this reasonable basis?
Sure. So one way to form the reasonable basis is the advisor could ask the third-party rating agency for the survey, and they could review it and confirm that it's reasonable. We understand that many rating agencies aren't willing to give their questionnaires, or it's difficult. So there are a few other ways that the adopting release discusses for forming this reasonable basis. One other way is that an advisor could seek representations from the third-party rating firm regarding general aspects of how the survey or questionnaire is designed, structured, or administered. Also, a third-party rating provider may publicly disclose information about its surveys or questionnaire methodology that falls short of the actual survey or questionnaire, but still can give the advisor a reasonable basis for believing that it's fair. And in either case, the advisor could obtain sufficient information from these to formulate its reasonable belief without obtaining the proprietary data of the third-party rating agencies.
Okay, thank you, Scott. And Brianna, what can you tell us about enforcement cases that included third-party ratings?
So first, in September of this year, we charged a firm actually with violating the first general prohibition, A1, for including an untrue statement of material fact in the form of a third-party rating. That firm had advertised that it was rated a top 12 financial advisor by Barron's, when in fact it was rated a top 1,200 financial advisor by Barron's. And it had also misstated the title of another third-party rating it received that really significantly changed the meaning of the rating. So as we've talked about, throughout the day, general prohibitions can definitely overlap with the specific provisions for other types of other components of advertisements like third-party ratings. In that same September batch of cases, we also charged another firm for disseminating an ad regarding the length of time that it had received a third-party rating, and it couldn't substantiate that length of time. So here the firm had claimed that its principal had been named one of the top wealth managers by the readers of San Diego Magazine for 14 consecutive years without being able to substantiate that material statement of fact about the duration that they'd received their rating. So that violated the second general prohibition under A2. Both of these firms, as well as two others that we charged at the same time, also included in their advertisements third-party ratings, some of which were rather old. There was some that were 17 years old, some over 20 years old. And they included those older third-party ratings without disclosing the dates on which the ratings were given or the periods of time on which the ratings were based. Those are required disclosures under the rule, and so they were charged with violating those provisions for not including those disclosures.
Okay, thanks, Brianna. And Melissa, can you discuss what issues you are seeing on exams for third-party ratings, in particular what you have seen related to advisors forming the reasonable basis and direct or indirect compensation and overlap with the general prohibition?
Sure. Similar to what Brianna mentioned a moment ago, we do see an overlap here. As with the testimonials and endorsements and performance, there's an overlap between the more specific elements of the rule for third-party ratings and the general prohibitions. For example, we've seen advisors making statements about being rated for multiple years when in fact the advisors did not receive the rating for all of the years in the range provided. That would be citable as under the third-party ratings aspect of the rule, but it would also be an untrue statement that is misleading under general prohibition number one. Again, similar to Brianna's observations, we've seen advisors missing basic elements of the rule, advisors not developing compliance processes to ensure that it can form the reasonable basis required under this part of the rule, and advisors not taking steps such as obtaining or reviewing the questionnaires. We also see a lot of compensation issues, such as advisors failing to disclose that they've paid to use third-party rating logos in advertisements, application fees to be considered in the rating, or paying for heightened exposure in third-party ratings. And relatedly, we've also seen books and records issues where advisors satisfy the survey element of the marketing rule, but then fail to maintain the associated records required under 2042.
Great, thank you. Thanks, Brianna and Scott. So we're getting close to the end of our panel time, and we started early, so this worked out. So as we come to the end today, does anyone have any final thoughts or key issues that might be next on the horizon in relation to the marketing rule? Can people contact you if they have questions?
So I am the Division of Investment Management. Is happy to take questions from the public. We're happy to discuss questions or concerns that individual firms are facing. I am also issued FAQs on the marketing rule, and these try to address the questions that are frequently asked by you. So that helps us. You sending us questions helps inform those. You can contact us by phone, and that number is 202-551-6825, or by email at imocc@sec.gov.
And many firms that comply with the marketing rule also claim compliance with the GIPS standards. And we created a white paper that is on the GIPS website that reconciles the requirements of the GIPS standards to the marketing rule. We also have some other marketing rule related resources there as well. You can find all of this information on the GIPS website, gipsstandards.org. And on the website, we have an email address for the GIPS help desk. Feel free to send an email there, and we are happy to answer any questions you may have about performance.
And we get asked a lot about whether there will be additional risk alerts under the marketing rule. I will say we find risk alerts to be a valuable tool for improving compliance. And while we can't guarantee additional risk alerts will be issued, I would point out that the content of the first one only covered about a third of the rule, the general prohibitions. Marketing related issues are topics covered frequently in deficiency letters, and we are open to drafting and will consider the appropriateness of additional risk alerts on marketing.
Great. Thanks to all of you who tuned in to the marketing rule panel today, and a special thanks to Karen, Brianna, Scott, and Melissa for sharing your thoughts. I believe that the next panel starts at 3 p.m. and Marshall Gandy will be introducing that panel when it gets closer to 3 p.m. So thank you all.